Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live after an extended weekend. I hope you're all doing well. Lots of courts still waiting to come online, but in the meantime, we're going to start our day in Genesee County, Michigan. This is Judge David Goggins.
Find defendants failed to appear today. There was a subpoena issued. So, yeah, it looks like it's got listed out, everything.
Right, Judge, this was for documents. So in other words, I think the creditor exam already took place and this was a continuing one for documents.
Oh, you know what? You're right. From looks like January 6th, maybe.
Yeah. Righto.
Okay. All right. I guess given, and I do, now that you say that, I do remember there were documents that didn't be trained. Let's just do show cause, I guess, for when's our next date there, Chad? We got, but I guess 10 days out or so. But yeah, on a Tuesday. Yeah, but it'd be 2 weeks, I guess. I give them enough time. Yeah.
Yeah, we just got to have time to serve that. Get that motion done and get it filed with the court and serve it.
If I do, say it's February 3rd work, that gives us a couple weeks out. I can go out further. It's up to you, Sarkat.
Yeah, Judge, I would actually go out. I would actually go out further. I don't know if you can do the maybe the 10th of February.
Yeah. Yep. How about February 10th?
All right. So February 10th of 2026, and still at 8:30 by Zoom. Is that right?
That's it.
All right. And then, Judge, does the court wish the show cause subpoena served by mail or by personal service? I was just looking.
If this one here, if he's not going to here, yeah, I guess it's he. Mr. Frank doesn't show up, I'd be willing to issue bench warrant at that time. So if you want to do, if you can get personal service, it'd be better.
All right. Let me see what I got. Okay. All right. Let me see what we've got here. All right. So thanks a lot.
Okay. That's it.
Thanks.
Do you have other ones? Was that it for you?
No, that was actually it. Yeah, that was it.
All right. Thanks.
Yeah, have a good. Thanks. Happy New Year.
Yeah,
thanks.
Bye. And how about Oliphant Financial versus Kimberly Birchmeyer?
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff.
You there? And how about Kimberly Birchmeyer? Kimberly Birchmeyer, anybody? Nobody responding. Looks like I got nobody in our meeting. Let's see. This is actually an adjourned date. Looks like the defendant did not appear the last time.
Yeah, it looks like we were here December the 2nd, Your Honor, in regards to a creditor's exam. She was personally served that. So this was the order to show cause for her not appearing then.
Okay. Fine, defendant failed to appear today. Do you want a bench warrant then?
Yes, please, Your Honor.
Okay. We'll issue a bench warrant. Defendant failed to appear.
Your Honor, as to
Yes.
bond,
Yeah, I was just gonna ask you what you tell me first which
the outstanding amount is $15,291.31. That's the outstanding amount on the debt.
Yeah, obviously you get that full amount. How about we do a 5,000 cash?
Okay, thank you, Your Honor.
Sure. We'll do that on that one. And Selson, do you have other ones too?
Nothing further. Thank you so much, Your Honor. We'll get that submitted.
All right, thanks.
Thank you.
Yep, bye. How about portfolio recovery versus Sean Urban? Anybody? I think I got somebody coming in. Portfolio recovery versus Sean Urban.
Morning, Your Honor.
Morning,
Attorney
Mr. Johnson.
Yeah, good morning.
Let's see. Do I have a Sean Urban? Anybody? Looks like I got nobody on our Zoom meeting. This is set for summary disposition motion today. files in order. Mr. Johnson, do you want to proceed with the motion?
I don't know if you want to give him more time. I know it took me a little while longer to get into court today. I don't know. It's up to you.
You know what? When you mean more time, you want me to just pass on it, or you want me just to give it a week?
Well, let's go with it. It's okay. He's not
Oh.
here. It's 8:45, I guess, is
If
what it
somebody
is.
does show up, what I usually do if they're on Zoom by now, that but I don't see anybody on here. So let's
Okay.
just proceed if you want to do that.
All right. Well, let's do it.
Okay. It's all up to you. You can proceed for me.
Hey, Your Honor, thank you. This is plaintiff's motion for summary disposition. This relates back to a purchased credit card debt. Balance suit for $3,503.30. Mr. Urban has not responded to the motion. I don't believe so. I didn't get a copy. He's not in court today. Just based on the court rules, I think we're entitled to a judgment.
Okay, and the one I did have an answer file, but no response to the motion. And I could get a chance to review the pleadings with the attached documents. Significant number of billing statements going to the defendant, Sean Urban. See if I got the same. At 300 Terrace Drive, apartment 78, and actually his answer to the complaint has that same address as well. Looks like the pleadings are in order. The attached documents for support for motion for summary disposition I've reviewed. Find there's no genuine issue of material fact. Grant motion for summary disposition pursuant to MCR 2.116. What was this brought under? Was it
I think
C10? Yeah, there it is. I do see C9 for sure. Yep, both C9 and C10.
Okay.
Grant motion for summary disposition. And Mr. Johnson, looks like I got an order granting your motion attached. I'll sign that order for you.
Perfecto. All right.
Looks like you're all set.
All right. On to the next one.
Great.
I don't know about you guys, but I don't think lawyers say the word perfecto quite enough. Good morning once again. Welcome to TCF Live on a Tuesday. Barbara, thank you for gifting a membership. Great way to start out the day. Very much appreciate that. Let's change it up. Let's go down to Georgia. This is the all-purpose calendar with Judge Eric Morrow. Still waiting for some other courts to come online.
What will be the truth, the whole truth, and nothing but the truth? Thank you. You can place your hand down. Yes, Ms. Spear.
Yes, Your Honor. This is Malcolm Wilson, position 64 on today's calendar. On count one, the state is recommending 12 months served, 34 days, credit for any time already served, balance probated. Stay away from the Goodwill at 1155 Mount Vernon Highway in Sandy Springs, 40 hours of community service. On count two, the obstruction, 12 months probation to run concurrent to count one and the statutory $300 fine. In count three, the false info to a law enforcement officer will be 12 months concurrent to count one. We do ask that defense stipulate to ID, venue, and factual basis for the plea. Thank you.
Mr. Dodd.
We stipulate for purposes of the plea, Judge. My client has been in custody 17 days, which will mean time served. He does have a Clayton County hold, Judge, so as soon as we're done, Clayton will come pick him up. I would request the court to consider a non-reporting probation upon completion of the conditions, Judge.
Okay, Mr. Wilson, it's my understanding that in case 26 CR 000102F, you wish to plead guilty to loitering and prowling, willful obstruction of law enforcement officers, and giving false information to law enforcement. Is that correct?
That is correct. Would it be a discrepancy if I was to plead NOLO?
Has a NOLO plea been discussed, Mr. Dodd?
No, Judge, I literally just met with him this morning and he just mentioned that he wished a NOLO plea. And I apologize, Judge. I should have asked. I don't know if he's eligible right offhand, Judge.
If not, it's okay. I'll still take it.
I would say.
Okay, do we have anyone, Mr. Howard?
Your Honor, we'll withdraw that request, Judge. She's going to proceed with a guilty plea.
Sure.
Okay. So it's again, it's my understanding that you wish to plead guilty to these three charges. Is that right?
That's correct, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Wilson. When you complete the terms, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you, Judge. Mr. Wilson.
I appreciate it.
Item 58, Mr. White, Willie White.
Well, the next contestant comes up. Ronnie, thank you for becoming a channel member. Welcome. You've just joined the best community in law to bar none, and I don't just say that because it's the channel I run. These people are just wonderful. So you have access to the pre-show now. That starts a half an hour before this show, and you'll see that come up in your feed. As well, you have the ability to call in and talk to me in the fourth hour. To do that, make sure, if you're not already on our Discord, which I'm sure Barbara's about to drop a link to, that you join us on Discord, and make sure that your YouTube login, your YouTube account is linked to Discord, and then that gives you access to the member area where every day I post the link to be able to join me in the fourth hour. So again, welcome.
In East Point, we also request that defense stipulate to ID venue and factual basis for the plea. Thank you.
Mr. Dodd?
Your Honor, we stipulate for purposes of the plea, this would be a time served sentence based on my calculation. He has served 18 days. I would ask the court to consider waiving the first 2 months of probation fees and perhaps non-reporting upon completion, Judge, of the conditions.
Does Mr. White need assistance with housing?
He does, Judge. I believe, and haven't confirmed it yet, social workers spoke to him initially, but I'm going to have them talk to him today, Judge.
Okay, thank you. Mr. White, it's my understanding that in case 26 CR 0000100A, you wish to plead guilty to criminal trespass. Is that correct? He has his hand up there, Mr. Dodd.
Yes, sir.
You don't have to say.
Oh, okay. I didn't know if he had a question. Are you under the influence of any drugs or alcohol this morning?
I can't remember.
Are you
Oh,
current? Right.
Oh, no.
You've been represented by Mr. Haddad there. Are you happy with what he's done for you?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that because you're pleading guilty to it, you're giving up that right?
Yeah.
Has anyone forced you to plead guilty? I'll accept the plea as negotiated. I will waive 6 months of the probation fees to help him get on his feet. I do want him to have a social worker visit to assist him with any housing requirements. When he completes the terms, I'll have it go to a non-reporting status. Good luck to you, Mr. White.
Thank you, Judge.
So, will I be getting out of jail today?
You should be.
You didn't hear me?
Oh, yeah. So I'm not sure what else you have to do today, Mr. White. I believe you're finished with my court. So if you have some other charges that are pending, I take it that's what this is, Mr. Dodd. Is that right? No?
He does not have any other holds, so what I told him,
Okay.
it'll take him until tonight or possibly tomorrow morning to process him out, but he should be released after this case.
Okay. All right. So you have the answer to your question, Mr. White?
Yes, sir.
All right. Good luck to you, sir.
Thank you, Judge.
You're welcome.
Or Mr. Watson.
Your Honor, I believe that's Ms. McLeod.
Ms. McLeod, are you with us? You might have stepped away for a moment. Can we
Your
go?
Honor, I'm here. I'm
Oh,
sorry.
can we
Your
go?
Honor, I'm here. I'm sorry.
Okay. No, you're fine,
I was
Mrs.
having
Klaus.
difficulty unmuting. I am here.
This is Mr. Watson, position number 54. What are we doing with him this morning?
Mr. Watson?
Yes.
Your Honor, he's just listed as conflict. I'm not sure if
He's not my client, Your Honor.
signed yet.
Yes, I am. No,
Okay, you've talked with Ms. McLeod before, Mr. Watson?
that's in my last call. That was, I think that was you. Your Honor,
Okay.
I think I pulled that information from first appearance, Judge, when I looked at the calendar. I'm not sure who the attorney was, the conflict attorney, but it was noted there was a conflict case, Judge.
Okay, well, can we have you handle that case, Ms. McLeod? Is that possible?
I could not handle it this morning, Your Honor, because I have 5 clients on this morning, and I went to the jail yesterday and spoke to all of them. So I didn't know about him, and I actually have another matter in DeKalb County. So I was asking that all my clients. That's why I went to speak to all of them from yesterday, so I would know what they were doing.
Okay. So, Ms. Spear, I see that the state is requesting 120 days. Do you have any idea of how many days? Is this a time served plea or not? Do you know?
It would not be, Your Honor, no.
Okay, so Mr. Watson, given that it's not a time served plea, I'm going to reschedule your case for next Tuesday, which I believe is the 27th. And Ms. McLeod, if you wouldn't mind handling that for the court next week. Is that possible?
That is possible, Your Honor.
Okay, so Mr. Watson, I'm going to see you back next Tuesday.
All right. Number 55, Mr. White, Devin White.
And this is also your case, Ms. McLeod?
This is my client, Your Honor, and this is going to be a negotiated plea this morning.
Good morning, Mr. White. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, I am.
Thank you. You can place your hand down. Yes, Ms. Spear.
Yes, the state's requesting 12 months, served 32 days with credit for any time already served, balance probated, FVIP, no further contact with the victim, Jeanette Pullins. Stay away from the apartment complex at 3215 Cushman Circle in Atlanta. 40 hours of community service and no firearms. As a result of this plea, count 2 will merge with count 1. Thank you.
Ms. McLeod?
Yes, Your Honor. My client asked me to raise with the court the issue of no further contact because they're engaged and it was a dual arrest situation. Both of them were arrested. And she had indicated at the time of the arrest that she wanted to have contact with him. They had both indicated that, Your Honor.
Okay. Ms. Jeanette Pullins is with us. Now is your opportunity to address the court. Has your office had any contact with Ms. Pullins, Ms. Spear?
I was just looking it up.
And did you have to? I take it that you didn't have any direct contact with Ms. Pullins, Ms. McLeod.
Did not, Your Honor. I was not able to get her on the phone.
Okay.
It was, I can
But
confirm it
at
was
the
a dual
time-
arrest, but no, we haven't had any contact with her.
Okay, so until there's contact with Ms. Pullins, I will have no further contact. If she has a different request in the future, she can or he can petition the court to modify that portion of the sentence. Is he still
Thank
wishes
you, Your
to-
Honor. I will do that.
Okay, very good. If nothing further, Mr. White, it's my understanding that in case 26 CR 000119 see you to plead guilty to battery, family violence. Is that correct?
Yes, sir, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. White. When you complete the terms of the probation, I'll have it go to a non-reporting status. Right.
I did bond out on this charge like a couple of days ago. I don't know why. They haven't let me out yet though.
Okay, well, given that you've entered into a plea agreement today, you'll be released if you don't have anything else holding you as soon as the jail can process you out.
All right, thank you.
Yes, sir. Good luck to you.
Thank you, Your Honor.
Once again, good morning, everybody. Happy Tuesday. Welcome to TCF Live. I hope you all had a good extended weekend and you're raring to go for a Tuesday here. Let's go up to Michigan, Otsego County, where justice is best done in it's like a Monday here, where justice is best done in a converted pole barn. There we go. Judge George Mertz.
And then let's see here. Mr. Gallagher, 1 second. Mr. Gallagher, are you able to hear me okay?
Yes, Your Honor.
Okay. So let's go on the record in People versus Anthony Gallagher. This is file number 256872. The record should reflect Mr. Gallagher is present today by video from Otsego County Jail. If I could have counsel put your appearance.
Morning, Your Honor. For the record, my name is People.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Gallagher.
Mr. Trush, can you tell me the status of this file here today?
Yes, Your Honor. We have a agreement that we intend to enter into today to resolve the matter. Mr. Gallagher would plan to count 1, count 2, and the enhancements would be dismissed.
Mr. Roll, is that a correct statement of the plea offer?
It is, Judge.
All right, Mr. Gallagher, were you able to hear that?
Yes, Your Honor.
Is that the plea agreement that you've discussed with your attorney?
Yes, Your Honor.
And did you want to go forward with that plea agreement today?
Yes.
You raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Gallagher, are you currently on any kind of probation or parole?
No, sir.
You understand that by pleading guilty to count 1, which is possession of methamphetamine, that the maximum possible penalty that you could face would be up to 10 years and or a $15,000 fine. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at a trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during the trial and to not have that silence used against you, and the right to testify yourself at a trial if you wanted. Do you understand all those rights?
Yes, sir.
And do you understand that you're giving up and waiving all of those rights by pleading guilty today?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you can only do that by leave. And that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No, they have not.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty to this charge because you are actually guilty?
Yes, Your Honor.
The information I have indicates that this happened about a year ago on January 17th of 2025. Is that the correct time frame?
Yes, Your Honor.
At that time, were you present here in Otsego County?
Yes.
While you were here in Otsego County, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No, I did not.
Mr. Roller, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Trush?
Defense is satisfied.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
Done by the people.
No, I've none, Your Honor.
And are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Defense is satisfied.
Thank you. Mr. Gallagher, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Between now and then, you'll be meeting with someone from the probation department for a pre-sentence report. And you'll have an opportunity to review that with your attorney prior to the sentencing hearing. Mr. Trush, is there anything else we need to address on this file today?
Not on this file.
Mr. Rolla?
Thank you.
Mr. Gallagher, do you have any questions about how we're going to proceed with your case?
No, I don't, Your Honor.
Okay, thank you. That's all for this hearing today, and the court is going to disconnect.
Thank you. Have a
All right, Mr. Burke, we're still waiting for Mr. Dion's counsel. We have a bit of a snowstorm up here overnight and into the morning, so she's running late. So we'll get started with your case as soon as we can.
No problem, Your Honor. Sounds good. Thank you. Appreciate that.
Mr. Trush, did you have Mr. Drysdale?
I do. Is he logged into Zoom? The court had previously approved his Zoom appearance.
You see that, but I don't see him, so we'll just pass that for the moment. Sir, are you Alan Millsap?
Yes, can you hear me?
I can, thank you. All right, we're gonna go on the record in People versus Millsap, and this is file number 256912. The record should reflect Mr. Millsap is present today by video from Department of Corrections. Mr. Millsap, the court set this for a hearing today because we have a jury trial scheduled in your case for March. And we received some information that your attorney, Mr. Mataloni, passed away in December. Is that your understanding as well?
That's correct.
So I scheduled this hearing because I wanted to see where you were at in terms of counsel, if you were, planning on hiring your own counsel, if you wanted to request court-appointed counsel. Can you tell me where things are at from that standpoint?
Yeah, I have two new lawyers, Marcus Baldori and Robert Baldori.
Okay. And do you know, are they going to file appearances in the case? Because we haven't gotten that yet.
Yes.
All right. And is it going to be your intention to have them proceed with that trial as scheduled in March? Or do you know if they're going to be wanting more time since they're coming onto the case at this point?
It's my understanding that most likely they're going to want that to change so they have time to prepare.
Okay. All right. Thank you. Mr. Rolla, was there anything that you wanted to add for the record?
Judge, I was just indicating we haven't received any appearances yet either, but should they file them, obviously with them coming in, people aren't going to have an objection if they make a motion for them to
Okay. So Mr. Millsap, if you do talk to your attorneys, they need to file an appearance in the case so that we can start sending them mailings and so that they have access to all the filings. Once they do file an appearance, then the court will set this for another status conference. Hopefully that'll be, within the next 30 days or so. And then I'm going to leave that trial date on for now, but certainly if your attorneys request an adjournment and you don't have an objection, it sounds like the prosecutor won't, then that's something we can address later. Do you have any questions about that?
Yeah, I do not.
Okay. All right, thank you. That's all for this hearing today, and the court is going to disconnect.
It's TCF Live on a Tuesday, a quiet Tuesday out there, to be honest. Not a whole lot of court action at the moment, but it should pop off eventually. Sometimes coming out of a longer weekend, things are a little slower to start. But let's rotate back to Georgia and continue with Judge Morrow for a little bit.
It's Wilkie right here, positions 35 and 30 through 38.
And what are we doing with Miss Miles Wilkie this morning, Ms. McLeod?
Your Honor, we are requesting that all of her cases be placed on the next available jail trial calendar.
And so you'll file a waiver in the matter?
Yes, we've already filed waivers into all the cases.
Okay, very good. Good morning, Ms. Miles Wilkie. Your case will be returned to the division judge and you'll get notification of your next hearing date, ma'am. Good luck to you.
I also have Ms. Lupo right here, position 27. She's also Ms. McLeod.
Your Honor, Ms. Lupo is going to be a negotiated plea.
Yes, good morning, Ms. Lupo. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, I can't hear you. You're gonna have to scooch up for me or speak up. Okay, you can place your hand down. Thank you, ma'am. Yes, Ms. Speaker.
States negotiated 12 months probation, 30 days to serve with credit for any time already served. Stay away from all 5 below stores, especially the one located at 3612 Marketplace. That's the incident location. No further contact with the co-defendant Sekai, S-E-K-A-Y, Thomas, MH/BHET. We do ask defense stipulate to ID venue and factual basis for the plea. Thank you.
We do so stipulate.
Ms. Lupo, it's my understanding that in case 26 CR 0000115Y, you wish to plead guilty to theft by shoplifting. Is that correct? Say it again for me, please.
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right? Say it again.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Lupo. When you complete the terms, I'll have it go to a non-reporting status. Good luck to you, ma'am.
Thank you, Your Honor.
Let's head slightly more south. Wade Mercer starting his first appearances.
Mr. Chubb, and make sure you can hear you, please.
Señor Chop, mi nombre es Jordani Ricardo. Soy intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
Great. Mr. Chubb, you're back to first appearance this morning for the no valid driver's license charge. I saw you about this weekend.
Señor Chop, está de nuevo frente al tribunal por el cargo de no tener licencia de conducir, por el cual yo lo vi este fin de semana.
I'm appointing Mr. McDaniel's office to represent you and asking that you listen to your attorney.
Le voy a asignar a la oficina del señor McDaniel para que lo represente y le pido que escuche a su abogado.
Your Honor, I spoke to Mr. Chubb. He's going to plead of no contest to the charges listed.
Su señoría, hablé con el señor Chubb. Él se va a declarar no me opongo de los cargos, así como se le acusa.
Understanding he'll serve 10 days in the county jail. He'll have 3 days jail credit, be a $400 fine.
Entendiendo que tendría que cumplir 10 días en la cárcel, tiene crédito por 3 días y tendría una multa de $400.
It's been explained that any conviction can result in deportation and that there's already an ICE hold for him as well.
Le he explicado que cualquier tipo de condena puede resultar en la deportación y que él ya tiene una orden de parte de retención de parte de inmigración.
Signed his plea waiver form with his right to jury trial and call witnesses.
Él ha firmado la hoja renunciando a su derecho a un juicio y a llamar a testigos.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Gracias, señor Mitchell. ¿Está de acuerdo el Estado? Lo está su señoría.
And Mr. Chubb, did you hear that agreement?
Señor Chubb, ¿escuchó usted el acuerdo? Yes.
Mr. Chubb, do you have any questions about that agreement?
Señor Chubb, ¿tiene alguna pregunta acerca del acuerdo?
No.
No.
Is that the plea that you would like to enter?
¿Es ese el acuerdo que usted desea aceptar?
Sí.
Yes.
Mr. Chubb, I'm going to accept your plea of no contest to the charge of no valid driver's license.
Señor Chubb, acepto su contestación de no me opongo ante el cargo de no tener licencia de conducir válida.
I'm going to adjudicate you guilty of that offense and sentence you to 10 days in the Jackson County Jail.
Lo voy a condenar culpable de la ofensa y lo condeno a 10 días en la cárcel del condado Jackson.
Mr. Chubb, you have credit for the 3 days you've already served.
Señor Chubb, tiene crédito por los 3 días que ya cumplió.
And I've got to impose the fine set by state and county law, which is $400. That'll be a civil judgment.
Y le tengo que imponer la ley fijada por la ley del estado y del condado. Son $400 de multa.
Mr. Chubb, the jail will go ahead and notify immigration that you can be picked up at any time.
Señor Chubb, en la cárcel le notificará a inmigración que ya lo pueden recoger en cualquier momento.
So you'll actually finish this sentence while you're in their custody, most likely.
So, lo más probable es que seguramente usted terminará esta condena mientras esté ya bajo la custodia de ellos.
Do you have any questions?
¿Tiene alguna pregunta?
No.
No.
Have a good day, sir.
Que tenga buen día, señor.
We have Alvarado. And Mr. Ricardo, if you'd please introduce yourself to Mr. Alvarado, make sure he can see and hear you.
Señor Alvarado, soy Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
So, Corporal, I've got his name spelled differently. On the jail sheet, the interpreter request from the jail and the complaint don't match. So, Corporal, looks like it may be an error at the jail. Can you check the spelling of his name? Is it Alvarado or Alvardo, Corporal? Sir, can you spell your last name?
Señor, ¿me puede deletrear su apellido?
Alvarado.
Yeah, they missed an A.
Okay. So, Corporal, if we get those jail records correct, Mr. Alvarado, I'm going to appoint the public defender's office to represent you and ask that you listen to your attorney, sir.
Señor Alvarado, le voy a asignar a la oficina del abogado de oficio para que lo represente y le pido que escuche a su abogado.
Your Honor, I spoke to Mr. Alvarado. He's going to plead no contest to the charge as listed. The understanding he'll be sentenced to 10 days in the county jail with 3 days jail credit.
Su señoría ha hablado con el señor Alvarado. Él se va a declarar no me opongo ante los cargos, así como se le acusa, entendiendo que se le va a condenar a 10 días en la cárcel con 3 días de crédito.
Be a $400 fine imposed, which would be a civil judgment more than likely. He has waived his right to a jury trial and call witnesses and understands that any conviction can result in deportation.
Él también tendrá una multa de $400, que lo que más probable sea un fallo civil. Él ha renunciado a su derecho a un juicio con un jurado y entiende que cualquier tipo de condena puede resultar en la deportación.
Nothing else, Your Honor.
Es todo, su señoría.
Thank you. And Mr. Mitchell, is that agreeable with the state? It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está, su señoría.
Mr. Alvarado, did you hear that agreement, sir?
Señor Alvarado, ¿escuchó usted el acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
No.
Did he say?
No.
He said no. And is this the plea you would like to enter, sir?
¿Es este el acuerdo que desea aceptar, señor?
Pues no puedo solicitar una fianza, creo, ya no sé.
Well, I'm not able to request a bond, right? I don't know.
See, you already have a bond on the driving offense, but you do not have a bond. You're not entitled to the one on the immigration hold.
Usted ya tiene una fianza por el delito de conducir, pero no tiene derecho a una fianza en la retención de parte de inmigración.
I explained to you this weekend through an interpreter that if you post bond on the driving offense, you still will not get out of jail because of the immigration hold.
Yo le expliqué este fin de semana mediante un intérprete que aunque usted pagara la fianza, en el caso de manejar, no saldría de la cárcel como quiera debido a la retención de parte de inmigración.
So do you want to enter this plea or not?
Entonces, ¿desea aceptar este acuerdo o no?
Sí.
I
Yes.
want to accept your plea of no contest to the charge of driving with no valid driver's license.
Acepto su contestación de no me opongo ante el cargo de manejar sin licencia de conducir.
I'm going to judge you guilty of that offense and sentence you to 10 days in the county jail.
Lo condeno culpable de la ofensa y lo condeno a 10 días en la cárcel del condado.
I'm imposing the fine of $400 and giving you 3 days credit.
Le impongo la multa de $400 y le doy 3 días de crédito.
And I'm going to ask the jail to notify ICE to pick you up so you may actually finish this sentence while you're in their custody.
Y le voy a notificar a la cárcel que le avise a inmigración que lo pueden recoger, así que quizás termine esta condena bajo la custodia de ellos.
Do you have any questions?
¿Tiene alguna
No.
pregunta? No.
Have a good day, sir.
Que tenga buen día.
Thank you, Mr. Ricardo.
Thank you, Your Honor.
This case is Dennis Howard. I'm sorry, it's Howard Dennis. I apologize. Mr. Dennis, good morning. Mr. Dennis, you're here for first appearance accused. Good morning. You're accused of one count of obstruction of justice, Mr. Dennis. I received a call from the captain at the Sheriff's Department this morning advising us that they think that additional felony charges are very likely, depending on what happens today. So I'm just making you aware of that possibility. As far as this charge, there is probable cause, and I'm going to appoint the public defender's office to represent you for first appearance purposes. Mr. Dennis, let me see what Mr. McDaniel's position is and Mr. Mitchell's, and then we'll go from there. Mr. McDaniel, anything?
Your Honor, we just asked for some kind of reasonable bond. He lives around here. He's not going nowhere. I've already talked to him about he needs to bond out so we can go talk to the attorney as ASAP as soon as possible and, you know, whatever kind of legal actions that might be coming.
Okay, so the confusion on the name is the jail sheet says Howard Dennis in one place, and the other place it says Dennis Howard on the pretrial release sheet. Which is correct, sir?
I think it's William.
My name is William Howard Dennis.
William Howard Dennis is his name, so it's.
So Corporal, the pretrial release sheet is the opposite of the other paperwork. So it's William Howard Dennis. Okay, so Mr. Dennis, thank you. Mr. Dennis, the pretrial release sheet is not filled out. So I have no idea if you're employed. I have no idea if you're retired. What's your What's your employment status?
I am employed. I'm employed with Beard Equipment Company in Panama City, Florida. I work every day. I pay
And
mortgage. I'm trying to do it
How
all.
long have you had that job?
I've had that job for about 9 months when I moved from another equipment job in Panama City to there.
Okay. And how long have you lived in Jackson County?
I'm born and raised here.
Okay. Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. Howard, I'm going to set you the standard bond of $2,500. Now, whether you go ahead and post that bond or whether you wait to see if there's other charges is up to you. I was just advised there's likely to be additional charges coming, but we'll see what happens. You have the right to post the bond immediately and be released. You do need to understand that this bond has nothing to do with any other bond. If they charge you with serious felony charges like they're discussing, that would be a totally separate bond, probably much higher than this. You need to be aware of that possibility. But right now, that's your bond, $2,500 cash or surety. It's a pretty standard bond for this charge. You might be a conditional release candidate. The problem is these other charges that's kind of throwing a kink in everything. So hopefully they'll know the next day or two if there's going to be additional charges or not. Do you have any questions?
All right, sure.
All right. Have a good day, sir. We had some individuals just come in for first appearance, I think. Are y'all here for a first appearance case?
Court date, February 2nd, 9 o'clock.
Please, February 2nd, 9 o'clock. What's his name, ma'am? I'll try to call it next. Richard Glass. We have parents here on Richard Glass, so let me see him next, please. Mr. Glass, your mom and dad, stepdad?
Uncle.
Okay, your mom and your uncle are in the courtroom, Mr. Glass. You're here because you've been accused of one count of possession of methamphetamine and one count of resisting an officer without violence, Mr. Glass. There is probable cause for the charges, and Mr. Glass, I think you're entitled. I think you're entitled to a bond, Mr. Glass. Let me see if the attorneys have an additional thing to add before I set that bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell.
We just request to be subject to random UAs.
Thank you. Mr. Glass, I'm going to set you the bond of $5,000 on the felony charge and the bond of $2,500 on the misdemeanor. I have read your criminal history. I've also looked at your driving record and see some recent stuff as recently as within the last month, some driving with no registration or something like that that's still pending. So, Mr. Glass, your total bond is $7,500 cash or surety. Cash or surety means he can either put up all of it if he wants to and has the ability to, or he can go through a bondsman. That's what a surety bond is. His bond has a condition of random urinalysis. Because it's a drug offense, ma'am, that means that he can be given a drug test. And if he tests positive for anything in his system that he doesn't have a valid prescription for, he could go to jail with no bond. So that's a condition of his bond. Let me see if your mom has any questions. Let me see if your mom has any questions first, Mr. Glass. Then we'll see if you have any questions. Ma'am, do you have any questions? No. Mr. Glass, do you have any questions?
No, sir. You can test me right now. I'm clean.
All right. Well, you'll get a chance to use the phone in just a few minutes, ma'am. And whether y'all post bond or not, it's up to you. He's also going to be giving his notice for his next court date. Would that be the 3rd, February 3rd at 8:30 will be your court date. They're going to give you that notice, Mr. Glass. Thank y'all for coming, ma'am. After Mr. Glass, we have LaDalvin Wimes. Mr. Wimes, good morning. You're here for first appearance accused of habitual offender, driving while license suspended. That's a third-degree felony charge that you're accused of. No. Mr. Wimes, there is probable cause, and according to the Florida Department of Corrections website, you're on probation out of Gadsden County. You are still on probation, correct?
No, none of that is true. I ain't even in here for that.
You're not on probation, Mr. Wimes?
You talking about somebody else. I'm in here for a domestic charge.
This is Mr. Wines, the second one on the case.
I apologize, Mr. Wimes. I'm sorry. I'm confused. I was looking at Mr. Wiggins on my sheet. I took Mr. Glass out of order, Mr. Wimes, and so I was looking at the person after Mr. Glass. That's my mistake. Let me go back up to the one above Mr. Glass, which is LaDalvin Wimes. Mr. Wimes, you're accused of one count of tampering with a victim and one count of domestic battery by strangulation. That's what you're accused of. Mr. Wimes, there is probable cause in those charges. Mr. Wimes, I think you're entitled to a bond as far as I can tell. let me make sure that the attorneys don't have any additional information before I set that bond. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
So, Mr. Wimes, in your case, I have looked at your criminal history also, Mr. Wimes, and it shows multiple. It shows a prior battery by strangulation that was dismissed. It was dismissed, and then there's another battery charge, Leon County, obstruction of justice. No, that's this one. Okay, so not a whole lot of criminal history, but there's enough there, and the complaint's enough that I'm not going to give you a conditional release. But I am going to set you a bond because I think you're entitled to one. These are 2 third-degree felony bonds, Mr. Wimes. I'm going to set you my normal bond I set for people that don't have much criminal history, and that's $5,000 on a third-degree felony. You have 2 of those charges, so your total bond, Mr. Wimes, is $10,000 cash or surety. Cash or surety means you don't have to come up with all the money. You can go through a bondsman, Mr. Wimes. That's what a surety bond is. So in just a few minutes, you're going to get to use a phone, contact whoever you wish, friends or family or bondsman. You post the bond, you'll be released immediately. Mr. Wimes, if you're not able to post the bond, the public defender's office will be in contact with you at the jail. Mr. Wimes, you're also going to be getting a notice for your next court date, which would be February the 3rd at 8:30. Mr. Wimes, do you have any questions?
No, sir. So with the 10,000 bond, that means it's actually $1,000, right? $1,000 bond.
If they charge you 10%, some places will take less than 10%. Some places may take 500 up front and work with payments on the rest. But yes, 10% of the 10,000 would be 1,000, but that's negotiable with the bondsman.
Your Honor, somebody else has no contact with the victim.
Yeah, no contact the alleged victim, Mr. Wimes. Thank you, Mr. Mitchell. Now we get to Mr. Wiggins, Marquez Wiggins.
I'll actually credit Dawn on that one. She brought it to my attention.
She reminded you. Mr. Wiggins, good morning. Mr. Wiggins, you're accused of 1 count of habitual offender, driving while license suspended. Yours is the case where Department of Corrections website shows that you're on probation out of Gaston County. Are you still on probation?
Yes, sir.
Mr. Wiggins, I think you're entitled to a bond in the new charge, but not necessarily on the VOP. I'm going to ask the attorneys to see what information they have. Then we're going to go from there. Mr. McDaniel, anything on behalf of Mr. Wiggins?
Nothing, Your Honor.
Mr. Mitchell.
We just request a 7-day hold. I'll be in contact with Gaston County. I'll see if I can get in touch with possibly ASA Edwards. I can reach him a lot easier and see if we can get a warrant out for that VOP if they're going to go forward.
Thank you. So, Mr. Wiggins, I'm going to set you a bond in the new case. The bond in the new case is going to be $10,000 cash or surety. The reason the bond is that amount is because you're already on probation. That bond has a condition that you not drive a motor vehicle. The reason for that is you've got a habitual designation from 2024, I think. So you've got a 5-year suspension, so you can't be driving. But don't try to post the bond, Mr. Wiggins, because for 7 days, I'm going to hold you with no bond. I'm going to ask Mr. Mitchell to notify the authorities in Gadsden County and see if they're going to seek a warrant or not on the VOP. Have no idea if they will or not. If they don't have a warrant within 7 days, you'll come back to first appearance. I release that hold on you. You'll be free to post bond at that point. If they do have a warrant, we'll see if that warrant has a bond or not. So I'll see you in 7 days. Mr. Wiggins, any questions?
No, sir.
All right, sir. I'll see you in 7 days. Let's give him a notice for his next court date, please. That would be February the 3rd at 8:30. And who do we have next? My list is kind of mixed up. I'm sorry?
Dana McDonald.
Is it Deny McDonald? Mr. McDonald, good morning. You're back for your first appeared this weekend by Judge Garcia, I believe, for criminal mischief. The complaint, yes, I guess the complaint says over 100, but less than 1,000, but the complaint never gives any value at all to the damage that was allegedly done. So, Mr. Mitchell, I'm going to ask you to notify the officer and remind them that we have to assume it's the lowest degree crime, a second degree misdemeanor, if they don't put a value in there. So, Mr. McDonald, I'm appointing the public defender's officer to represent you. Please listen to Mr. McDaniel, your attorney.
Your Honor, we're just going to ask that Ms. McDonald get a conditional release and a court date for February 2nd, 9 o'clock.
The jail sheet says she was given a conditional release this weekend. Is that not accurate?
Well, her parents were going to post bond from Ohio, and they've had problems. I don't know. It's a $250 bond, but I think they're trying to go through a bail bondsman who probably is not going to write a bond on $250. And I don't know if they can't figure out how to send the cash.
Okay. So just a second, ma'am. Just a second, ma'am. I need some information from the jailer first. So, Corporal, I need your help with this one.
Hey,
So Corporal, the first appearance sheet says conditional release or $1,000 bond. I have not watched the video. Was she offered a conditional release this weekend or not? And Mr. McDaniel says 250, but my jail sheet says 1,000. So I need to be clear on that.
According to the first appearance sheet, she had a conditional release for $1,000 bond for the weekend.
Yes, it was a conditional release or $1,000 bond.
someone told me, it may have been her that told me someone called me this morning and I think it might have been the parents who were calling me. I was thinking they said 250.
So Ms. McDonald, you chose the bond, but then were unable to post it. Is that correct?
Yes, sir. My mom, I'm on scholarship. I play basketball for Chipola. My mom is in Ohio, so she told me to just take the bond so I wouldn't have to be going through probation and stuff like that because I am a basketball player and in school. So when I tried to do that, the bondsmen were like, it was difficult for my mom because she's 19 hours away. So then my mom said it would just be best when I have this again to just choose a conditional release.
Okay.
Because I'm just
So you
trying
want
to
to
get back
accept?
to school.
Okay, you want to accept the conditional release that Judge Garcia offered you this weekend, correct?
Yes.
Okay, I'm gonna grant you the conditional release. Judge Garcia's already granted that, so there's no problem with that. What that means is you're going to get out of jail this morning. And let me tell you what's going to happen. They're going to let you get dressed in your regular clothes, and then they're going to bring you, the jail's going to bring you to the courthouse because that's where the conditional release office is at. When you get to the courthouse, Mr. McDonald, you'll meet with Mr. Goodson or Mr. Ham, probably Mr. Goodson, the conditional release officer. You do conditional release? That's one. So Mr. Ham will meet with you, and then they'll go over the release with you. They'll give you a copy of all the rules in writing. They'll give you a chance to ask any questions, and then you'll be free to leave. You will have to be back in court on the court date of February 2nd at 9 a.m. They will give you that notice downstairs. They'll get you to sign for that notice. You do have a condition of no contact with the alleged victim, no contact at all with the person that's accused you of this. And you will be at the courthouse in probably 30 to 45 minutes. You can use the phone before you leave there to call friends or family to tell you for transportation purposes. You can be picked up in about 30 or 45 minutes at the courthouse after you meet with the officer. Ms. McDonald, do you have any questions?
No, sir. Thank you so much.
Yes, ma'am. Wish you the best. James Ammons.
James Ammons was returned to his cell, Your Honor, and next is Marley Owens.
Okay, Miss Owens, good morning, ma'am. I first appeared to you when I covered on Sunday, ma'am, for the charge of driving while license suspended or revoked knowingly. Miss Owens, I'm appointing the public defender's officer to represent you, ma'am. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Ms. Owens and she was going to accept the offer from the state, a 6-month probation for no valid driver's license, $400 fine. She can, if she gets a valid driver's license within 60 days, that fine will be lowered to $300. She has signed a plea waiver form, waiving the right to jury trial and call witnesses.
Okay, I don't know anything about that offer because I told Mr. Mitchell that I would not necessarily post a probation if she had a job, a real job. And I'm not sure why it'd be 6 months anyway, because it appears she's got a prior.
Yeah. Sorry. That's on
So I don't think she employment.
I don't think she has a prior.
I do have a
Let's
job,
start.
Your Honor.
Okay, Ms. Owens, the sheet from the first appearance pre-trial release sheet, the reason I didn't suggest probation to begin with is it says self-employed, and sometimes self-employed means you have a job. A lot of times it means you really don't have a job. So tell me about your employment, please.
Sir, I work for Hustle and Rubber. It's for my fiance. Underneath my fiance's, I get a paycheck. It's in Alabama, but I still get a paycheck. I mean, I get paid every week. It's called
How many
Hustle and
hours a
Rubber.
week do you work?
It just really just depends. Usually over probably at least 60 hours a week.
Okay, so how long have you had that job?
For last year now, I know at least last year, yeah.
Okay, so have you got your tax return forms yet for 2025?
Not yet, sir, but I'm just waiting on them in the mail any day now.
Okay, so it's at least 30 hours a week every week, right?
Yes, sir.
Okay, and I believe on my driving record, I saw a prior because I talked to you about this weekend, prior driving license suspended. Is that not correct, Mr. McDaniel?
I think they're unknowingly, she has two of them, just, and they're both unknowingly, and they're both sitting there. That's the reason I was trying to do a no valid driver's license, because
This is an old one. This one's. Let me look her driving record up. I know there were two recent or more recent civil ones, but I think there's an older criminal one, but let's double check. So I have no problem with the probation based upon her employment. The question is, how much probation would it be?
Yes, sir.
This was the one I also asked you about amending from DWLSR to no valid DL. So that's why it would be 6 months probation at that point if we amended it to no valid DL.
Okay. If she has no prior.
If she had a prior, I don't mind doing a year probation on a no valid driver's license. I don't have any objection to it, but I didn't.
You can only do that. You can only do that if she has a prior no valid, though, if you're going to amend it. So let me go back and just because she does have a prior criminal driving license suspended in Holmes County in 2015.
Okay.
There are no prior civil ones showing up at all.
Okay.
Don't, you done messed up my stack. What do you need? You need something out of here?
Yeah, because I didn't just write the bonds.
Okay, well, hang on just a second. Let me. Okay, so knowing that she has a prior, I don't know anything about the civil ones Mr. McDaniel was talking about. They may be pending or something, but they're not showing up on the driving record. Do you still want to change it to no valid driver's license?
Yeah, I have no objection to that.
And if you change it to no valid driver's license, does she have a prior no valid driver's license?
From that, I did not see a prior no valid DL.
Because
at least when I was looking through
that
it,
wouldn't necessarily show up on the driving record. Okay, so you need to understand, Ms. Owens, if I give you the 6 months on the no valid driver's license, I'm not going to let you terminate probation early because you have a prior
I understand
driving
that,
license
sir.
suspended or revoked. You're going to do the full 6 months. Knowing that, do you want to enter this plea?
Yes, sir.
All right, so I'm going to accept your plea of no contest to the charge of no valid driver's license, the amended charge. I'm going to withhold adjudication of guilt. I'm going to sentence you to 6 months probation.
Now, sir, will it help in any way?
Just a second. Let me get through and then I'll answer any
Okay,
questions you
I'm
have because I've got certain things I have to put on the record. Just a second. 6 months probation, no early termination, $400 court costs and fines, withhold adjudication. You'll be brought to the courthouse in just a little while, ma'am. You'll get to use the phone before you leave the jail. And then this case will be over other than you carrying out and completing the terms of your probation. Now, do you have questions, ma'am?
So when I get my driver's license fixed, it's not will it be helpful to that or?
It
or
will,
is that one
it
of my-
will. And let me tell you how. If you get a license within the first 60 days, instead of your fine being 400, it'll be lowered to 300. Yes,
Okay,
ma'am.
then that's all I needed to know. Thank
Any
you
other
so much.
questions?
No, sir.
Mr.
Thank
Goodson
you
has
so
a
much, Your
question.
Honor.
Thank you. Those are standard conditions I always put on there, and I forgot to do them this time. Mr. Goodson's reminded me. You do have a condition that you obtain a driver's license if one is reasonably available to you, and that you not drive a motor vehicle unless you have a valid license. Knowing those additional
sir.
conditions are there, do you still want to enter this plea?
Yes, sir.
All right, ma'am. Wish you the best.
Thank you so much.
Thank you. Mr. McDaniel, that's everything I had on my list as far as I can tell. Anything else from the public defender's office?
Good morning once again, everybody. It's TCF Live on a Tuesday. I hope you're all doing well and enjoying your day so far. Courts are starting to come online right now, but to be honest with you, the 14th Circuit here in Florida is kind of where it's at. There's a few judges that are streaming at the moment. Let's go over to Brantley Clark.
This case is being transferred to county court from submitting a PIA.
10 more.
That's it. They'll give you some paperwork. I was released this afternoon.
Thank you.
Mr. Ross? This is Ronald Ross, case 25-3839. The information's been filed with knowledge of receipt of it, waive a formal reading. enter a plea of not guilty, subject to any pretrial motions. Need to do a little discovery, a little plea negotiations.
When you want to set this?
If we could have the March pretrial, if I get something accomplished before then, I'll bring him back earlier.
Is that March 19th?
That's
March 26th at 9 o'clock.
Be back up. Yeah. Okay. And Ms. Page? Now, this is Heather Page, 253908. Mr. White says an information is being filed this morning, but
Information, are you filing one right now, Mr.?
Yes, Your Honor. It should be in the, it should be being processed.
That made the, what you want to do?
Mr. White told me it was a different charge. It was going to be felony battery.
I just filed on the felony battery.
If that's the case, I believe the aggravated assault had a $25,000 bond. I think that should be reduced to ROR.
No objection.
So you want to go ahead and enter a not guilty plea to the information is filed in the process?
Yeah, I trust Mr. White. I want to file it, and I'll get the discovery as soon as that's done.
What I'm going to do is our ROR, Ms. Page, on the aggravated assault, still has the $5,000 bond on the felony battery with the same conditions of the bond. What do you want to say?
If we could have that same March return date.
26 at 9 o'clock.
Let Ms. Page know that if she does bond out, to keep my office and the clerk's office updated.
Absolutely. If you bond out, you need to contact the clerk's office and stay in contact with Mr. Meredith.
Because that court date may change because that's for people in jail. Okay?
Okay,
All right.
thank you.
Thank you. Ms. Beasley?
Good morning, Your Honor. I have James Crow. Honor, Mr. Crow's case is with Mr. Sullivan. His case number is 253990, and information has been filed when a plea of not guilty demand for discovery trial by jury. He's set for a bond motion on January 23rd.
I will leave that on the Friday, and then we will set a hearing, another hearing date after that.
Thank you. Michael Leathers. Honor, Mr. Leathers is coming before you. His case number is 253830, and information has been filed by Mr. Sullivan. Enter a plea of not guilty demand for discovery trial by jury. If we could pass him one rotation, Your Honor, I need to spend some time with him out at the jail. February, please.
February 19th at 9 o'clock.
Okay, come out and see you. February 19th.
Appreciate it, man.
Okay, you're welcome.
Thanks so much.
Your Honor, I have John Kuzniar as a self-rep. Mr. Kuzniar in the box? No? Sorry, Your Honor, I had him. I marked him incorrectly. I have Justin Mann. This is with Mr. White. Mr. Mann has a new law in case 253965. I don't see an information file. And he has a VOP in 242010. We'll enter a denial in that VOP case.
Your Honor, this is a new law. There's a new law and a technical violation for the VOP. I'm filing a no information, and on this case, it was a mutual combat situation where there was a companion misdemeanor that was also dismissed for the same reason. And at this time, with the only technical being a small arrearage on fees, the state would dismiss the violation.
Mr. Mann, you are released
from custody on the, state's, charging decision not to charge you with the, new battery. Based on that, state is pursuing the affidavit of violation of probation, so you're released back to probation. So you're released from custody. I would step up and speak to probation officer.
Okay.
Yes, so you okay?
Your case
Good
is
luck.
done. You're still on probation. Go this way and talk to probation, okay? Eric Taunton? Eric Taunton, it's with you. Your Honor, this is Eric Taunton. His case number is 253700. There has been an information file. Will enter a plea of not guilty, demand for discovery, trial by jury. He also has case 253970 that we were arraigned on. I guess we're here for arraignment on that one too, Your Honor. Enter a plea of not guilty in that one also. Asked for, I think February, give you enough time. If we could come back in February, Your Honor, he's looking at the possibility of hiring a private attorney.
Yes, sir. Come on.
Ms. Robinson, if you want to.
Let's switch it up a little bit. Let's rotate over to Texas. Judge Stevens is getting his day going now.
Okay, sir.
So you are Logan Birdsong? That's probably me. I'm all the Are you? What are we doing today, Mr. Walker? It's an announcement?
If we still we could get together, I would say if the court needs to settle on the trial docket, I know it's getting a whole.
Yeah, we need to do that, I
Yeah,
guess. It's 2 years.
Yeah.
If we work it out before then, I think I've got an offer in mind, but I've got to talk to him about it. And it's something we need to discuss.
Okay.
So
Do we need a review on this soon or just let it
just put it on the
roll
trial
over?
docket because there's
think
no guarantee they're going to like what I offer
I
them.
think that's going to be.
Sir?
I said there's no guarantee they'll like what I offer them, but yeah.
I think that'll be.
All right, well, then it's set for trial.
Yes, sir.
Yes, sir. Thank you. And I've got two others, right? One, Figueroa and Gerardo Galvin. Gerardo, are you Gerardo Galvin? Figueroa?
Figueroa.
Come on up. There are two cases and Figueroa.
And this is our first setting. I mentioned on this. It's. Something to give up.
And two cases are called 25 CR 730 and 731. Both are similarly charged with the crime of second-degree felony assault on a peace officer. You are Juan Jesus Figueroa. Is that right? That's right. Yes, sir. Mr. Walker is here representing you. Each of these are second-degree felonies, which carry with it, if convicted, up to 20 years in prison in each case. Do you understand, sir? Sure. Okay. And announcement today is.
I'm going to get with Mr. Ham. I have a feeling we'll be able to get these.
What are you asking for? What did we said to? Is 4 weeks going to be enough?
Yes, sir.
Okay, good. All right. 4 weeks, get a resetting?
Thank you.
Thank you. Yes, sir.
Resetting it for that.
Announcement, yeah. And Gerardo Galvin is not here yet.
Yeah, he may be out, but he won't make it ship up 95.
Okay, let me know if he's in. So
Thank you.
yes, sir. Langston, you
Yes,
got
sir.
a gaggle of cases, buddy.
Yes, sir.
I think that's what they call more than one criminal case, a gaggle.
Yeah, everybody's here too, Judge.
Claiborne Livings.
He is here. So that's
You almost hesitated
No,
on
that's
that
the wrong
after
part.
you said everybody's here. And you said,
That's what I was asking.
He is, yeah, Mr. Livings
That's gonna be a plea. But Judge, I think he's,
today.
yeah, that's plea. I'll sign him up now. But look, I think you skipped the amount like that. That's the 9:30.
Yeah, we jumped to the 9:30. I was looking at Judge Walker's matters.
Let me
and
get
taking
that.
care of this stuff. Yeah.
Let me on that 9.
Okay. All right.
So he's a plea. I'm signing him up now.
Okay. I've got Spencer Gyron.
Yes, sir. Come up. Absence.
'25 CR 733. Failing to comply with sex offender registration duties. This is initial appearance. You are Spencer Gyron. Am I pronouncing that right? Jaron. All right. This is a third-degree felony if convicted, which carries with it up to 10 years in prison. Serious. And Mr. Adams is representing you. What do you want to do today?
Your Honor, he's gonna be in my office tomorrow. I just want to move it to an announcement.
It is done. It'll be set for announcement. Please get a resetting from that lady. Thank you. Daquan Pugh.
He's here too. I talked to him this morning. Mr. P.
25 CR 1471, Daquan Pugh.
I talked.
No answer in the courtroom.
I talked with him outside.
I'm going to ask the bailiff to call outside. He may be a little shy today.
Yeah, I know he's here. I talked to him outside.
There you go.
He should. I'm hoping he's outside. Yeah. See? Yeah. Don't forget, come tomorrow, 4:00 push. This should be walking on Judge.
Man.
No answer, Your Honor. Oh, but I know he was here. I'm positive.
What'd you say to us?
I didn't think he was leaving.
Yeah, he's gone. He took off.
Well,
All right. Well, if he saunters in, let me know. But there is no answer for the name call here in the courtroom for Daquan Pugh, who was to be here at 9 o'clock on this initial docket. There is no answer to the name Daquan Pugh being called into the hall. Defendant has failed to appear. A warrant shall be issued for his arrest for failure to appear as required. His bond is
$100,000.
My goodness.
And Judge, if he does come in, we do have a note, he needs to redo the indigent paperwork.
No problem.
The defendant has to do that. Okay. The bond is revoked. It is doubled to $200,000. Plus, he must have a GPS device and home confinement due to his failure to appear. All right, those are the findings and rulings. Hakeem Richard.
He's here.
You said that fast.
I hope you didn't leave either.
Were they driving together? He and Lance?
I didn't tell him was leaving.
He and Daquan?
Hakeem, he might be outside.
Richard? No answer in the courtroom. I asked the bailiff to call into the hall for Hakeem Richard.
You know, I know. I know he's here because he. Richard. Richard. I had talked to him when I talked to Mr. Poulard.
He's got these two priors. That bumps it up just to a third degree. Is that right?
That's correct, Your Honor.
Oh. All right. There's no answer.
No,
to the name called here in the courtroom. No answer.
I talked to Mr. Poulard. I talked to Mr. Yeah, that's Poulard right there. I talked to Mr. Jeffrey. He was outside.
He's not there now.
I don't know. I have no idea.
Is this a Twilight Zone episode we're seeing? They're evaporating?
Hey. I hope they come back. I hope.
All right. Well, there's no answer to the name called here in the courtroom and no answer to the name called in the hallway. Defendant has failed to appear. Warrant shall be issued for his arrest, and his bond was,
$6,500.
and it is doubled to $13,000, plus he must have a GPS device as a condition of his bond.
I'll let you know if he come back. Just let me sign up Mr. Livings now. I can, because that's the 9:30 document. I can
Is there
start.
anybody else who's hidden here that you're representing?
Well, I had 1 out of 3 show up.
Yes.
Hey,
Well, it's a 333 batting average. That's pretty good for the majors.
that's pretty good for the majors. All right, let me get with Mr. Livings.
Braden North.
Oh,
Braden North in cause number 25 CR 1189 is called. And there's no answer to that name call.
oh, no.
Yes, everybody's riding together in the same slow car. I asked the bailiff to call into the hall for Braden North. He's coming a long way from Hallisville.
That's a good one.
Famous movie was filmed in Hallisville. What movie? The Alamo. There's no answer to that name being called into the hallway. No answer to the name called here in the courtroom. Braden Terrell North has failed to appear. A warrant shall be issued for his arrest. His bond is revoked.
$5,000.
His $5,000 bond is revoked. It is but doubled to $10,000. Plus, he must have a GPS device as a condition of his bond, since we're having a hard time finding him. Anybody ready to go forward on 9:30 early? Any defense attorneys want to try their luck?
I'm ready, but actually I'm not ready. I need to lift your hand.
But at least you're here. That's important.
Yes.
You broke a long streak we had there for a while. All right, short recess. Short recess, 10 minutes.
All right, well, they wait for contestants that actually show up. Let's rotate back to Michigan and the pole barn justice with Judge Mertz.
Is to my right.
All right. We have the set for entry of a plea here today. Ms. Madison, is your client ready to proceed with that?
He is, Your Honor.
What are the terms of the plea agreement in this case?
Judge, under this plea agreement, Mr. Dion will plead guilty to 3 counts of failure to pay child support with a habitual second. And the state is offering a sentence agreement for a delay of 11 months. During that time, he must pay as ordered every month. If he's able to reduce his arrearages to $18,000, then he can be sentenced on 1 count of attempt failure to pay child support. If he's able to reduce his arrearages to $0, then he can plead guilty to 1 count of disorderly person. And the prosecutor agrees to dismiss count 4.
All right, Mr. Burke, is that a correct statement of the offer by the people?
That is correct, Your Honor. Yes, thank you.
Okay. Mr. Dion, have you had an adequate opportunity to speak with your attorney about this agreement?
Yes, sure, I guess.
I don't want you to guess. If you need more time to talk to her this morning, I'll give you an opportunity to do that.
I mean, I don't think that I think this is the only deal that they could come up with, so we can continue.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Thank you. Mr. Dion, are you currently on any kind of probation or parole? All right. And you understand that the maximum possible penalty for each of these 3 counts as a second habitual offender would be up to 6 years. Do you understand that?
Yes, sir.
With that in mind, what is your plea to each of those counts here today?
Guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights.
That's right.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
That's right.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then you wouldn't be able to go any further with that appeal. You understand that? Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to these charges because you are actually guilty?
Yes, Your Honor.
Okay. And there are three. Ms. Madison, is the plea going to be to counts 1 through 3?
That's correct, Your Honor.
Okay. So, Mr. Dion, between July of 2019 and February of 2020, were you subject to an order here in Otsego County that required you to make child support payments?
Yes, sir.
And were you aware that you were subject to that order?
Yes, sir.
Did you fail to make payments in the amounts or at the times required under that order?
Yes, sir.
And did that also occur during a period between October of 2020 and January of 2021?
Yes, sir.
And then did that also occur between March of 2021 and January of 2023?
Yes, sir.
Okay. Had you previously been convicted of the felony of interfering with electronic communications here in the 46th Circuit back in 2016?
That should have come off my record because I completed the drug court program. It was 7411, I think they called it or something. And upon completion of the drug court program with Mr. Abe Cruz, that was not, it was supposed to be a high court misdemeanor, to my understanding.
All right, Ms. Madison?
Thank you, Your Honor. I was not aware of this until this particular moment. I don't know if the state is willing to amend the plea at this point. So there's not the habitual second.
In court last time, I said that there's no reason I should have an habitual felony because I mentioned me completing the drug court program.
Did that actually result in entry of a conviction to a lesser crime?
When I got sentenced, yes, that's what I signed the paper was for a lesser crime.
Mr. Burke?
Your Honor, my thought would be based on what the defendant's saying. It sounds like he maybe had a couple different charges. 7411 is for drug charges. This is it looks like the conviction is has nothing to do with a drug conviction or drug issue. So I mean, we could certainly look into it if the court's going to schedule what I refer to as a delayed sentence hearing, which is a hearing about 30 days out, that will result in the court placing the defendant on a delayed sentence per the plea agreement. Then we could certainly look into that. And then if there truly is a felony conviction for 2016, then the court can certainly take the factual basis for that at that time. If there's not, then the people would certainly move to dismiss that HAB second. I'm just not sure if the court is going to schedule a delayed sentence hearing. Some courts will place the defendant on a delayed sentence right away after the plea. Some courts schedule those matters out 30 days because the court wants to see a PSI first. So I'm not quite sure how this court does it, Your Honor, but if there's a possibility of maybe scheduling a delayed sentence hearing and about 30 days out, we could certainly look into that at that time.
Okay, so I think that's a good suggestion. Do you have any objection to that?
No objection.
So the way we're going to handle this, because Mr. Dion, I mean, there's a very detailed legal framework for when past convictions can be used for purposes of habitual offender enhancements. In your case, it's either going to fit within those or it's not. It should be a fairly simple issue. So Ms. Madison, I guess you're your client's the one saying it shouldn't count, so I'm gonna put the burden on you to look into that. If there's a statutory basis for to eliminate that habitual enhancement, then I don't think, I think the prosecutor would have to take it off.
Yeah.
So I'm gonna place that on.
And we certainly would, Your Honor, of course. So.
Yeah, right. So we'll go ahead and schedule this. And Mr. Burke, I do generally set him for a delay sentence hearing later after a PSI, and I have a PSI prepared and everything. So we would have been doing that anyway. So it's not going to result in any kind of delay to the case. And then we'll address that issue. Mr. Dion, your attorney is going to look into that for you. And again, if it doesn't apply, then we'll take it off of there. But it may, because there are circumstances where you can have, a conviction not be considered for the public record, but it still can be used as an enhancement, and that may be it in this case. But again, your attorney will look into that for you. So we'll set this for a delay of sentence hearing. You're going to check in, Mr. Dion, with Mr. DeLeo here for probation before you leave today to set up a time for a pre-sentence interview. And then just make sure that you stay in touch with your attorney, okay? Mr. Burke, anything? Yeah.
I was gonna say, just for the record, I just want to make sure that the court is aware that people are satisfied with the plea as well as the factual basis. The people are satisfied with the court has complied with the court rules for taking the plea. So I just want to make sure the record is reflective of that.
Yeah, thank you. I got sidetracked there from my usual colloquy, so I appreciate that. Ms. Madison, are you satisfied with those matters as well?
Yes, Your Honor.
All right, so then for the record, the court finds the plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that Mr. Dion is guilty of each of these charges. The court will accept a guilty plea as to all three. And again, Mr. Dion, just make sure you stay in touch with your counsel. Okay.
Okay.
Thank you.
Thank you, Your Honor.
And Your Honor, is one last thing, I apologize. Do we have a date and time for the delayed sentence hearing, or is the court just gonna schedule it and notice it out?
Yeah, we'll notice that out. It should be in about 30 days. And if you want to appear remotely for that, I don't have an objection to that.
That sounds great, Your Honor. Thank you. I'll let the Lansing office know. Thank you very much, Your Honor. Appreciate that.
All right. Thank you. That's all.
All right, let's head down to Texas. Judge West is getting her day started. Let's see what's going on.
For Asa Joseph Jones, in cause number 25, DCCR 0963, you're charged with aggravated assault, discharging a firearm recklessly. That's from June 12th of 2025, and that's a first-degree felony offense, which means if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Burbanks that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for 25 years in the institutional division of the Texas Department of Corrections. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? And do you want to reject this offer and have your case set for trial? All right, I'll get that done. As far as you know, all the discovery, you have everything. Okay.
We're not waiting on anything, Judge.
And is there any reason to believe that this offer would change, Mr. Coleman?
Not at all.
I want to make sure you understand, Mr. Jones, that after today, this offer will be off the table. If you change your mind later and want to enter a plea of guilty, you could do that open to the court or to some other plea agreement. But after today, this one's off the table. You understand? Okay, we'll get it set for trial. Mr. Burbank will begin preparation. Thanks. And then you have Kevin Ross. Okay, I'll take care of it in just a second. Let's get Calvin Randall. I can take care of Calvin Randall for Mr. Eckhart. We're just going on 2.
Yes, ma'am.
529. Thank you. I'll need, can you do 1 for each? It's easier for them. I'm going to mark out the second number. If you'll do 1530 on the second one, please. Mr. Smith.
You marked out 15030. I need to write 1530.
Correct, yeah, 1530 is what that one needs to be. And we're going on multiple counts.
They can both be counts on the judge. Usually we get 10.
All right, sir, you're Calvin Randall. And Mr. Eckhart, will your client waive the formal reading of the indictment in each case?
We do, Judge.
Mr. Randall, in cause number 24, DCCR 1529, you're charged with the second-degree felony offense of unlawfully carrying a weapon on alcohol premises, and I don't know what all those other letters stand for. IATWFZ.
That's the statutory name, Judge. I think it's in a either correction facility or something like that, but it's not applicable here.
Just, I'm looking at the indictment. It says unlawful carrying weapon, alcohol premises, IATWFZ.
I've seen that before. Weapons free zone. That's what it is.
Thank you, in a weapons-free zone. All right, and that is from May 17th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then in cause number 24, DCCR 1530, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from May 17th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the tablet in each of those cases some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Eckhart? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case?
No objection in each case.
It's admitted in each case. Is there any evidence that Mr. Randall is not competent?
No.
All right, Mr. Randall, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas, find sufficient evidence to find you guilty, and in cause number 24, DCCR 1529, find you guilty of evading arrest or detention. Good grief. That one is the unlawful carrying of a weapon on alcohol premises. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1530, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that for any time that you've been in custody that the law gives you the right to receive. These two sentences will run concurrently, which means together at the same time. I will sign as a part of this plea agreement the dismissal in cause number 24, DCCR 1278. In each of these cases, I'm going to hand you the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. Did I do, I don't think 1529 came through.
Okay.
Would you?
Yes, ma'am.
They're gonna, so also I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Eckhart. All right, good luck to you, sir. And we're going to get that other one printed out in just a second. I don't know what's. All right, thank you, sir. You can go back with the bailiff. We'll get it to you.
Thank you, Judge.
Thank you, sir. And do you have Kevin Ross's stuff?
Yes, ma'am. I'm sending you the last one.
See, Mr. Rojas, you have Jaquan Fontenot. Good morning.
Good morning. We'll be going to counts 1, 2, and 3, Your Honor.
Thank you. Good morning, sir. Are you Jaquan Fontenot?
Good morning, yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
And you guys have agreed to go on.
1, 2, and 3, Judge.
Mr. Fontenot, in cause number 22-39248, I have a first amended motion to revoke your unadjudicated probation, and will he waive the formal reading of that?
He will, Your Honor.
It shows that you were placed on probation December 14th of 2022 for the offense of theft of a firearm, a state jail felony, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department July 17th, July 23rd, and August 20th, and September 23rd of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to pay your court-assessed fees as directed, and that as of September 23rd, 2025, you were $3,505 behind. Is that true or not true?
True.
And then count 3 alleges that you committed the offenses of possession of marijuana, resisting an officer, and no insurance on September 9th of 2023 in Calcasieu Parish, Louisiana. And is that true or not true?
True.
And the state's going to abandon the rest?
Yes, Your Honor.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Fontenot is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of a firearm. Sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Let's see, relation Mouton. Is that a competency?
Then I'm gonna need a reset after that.
Okay. Good morning. Are you Relatia Mouton?
Yes, ma'am.
Good morning. And Ms. Mouton, I'm going to take judicial notice of the court's files and Ms. Mouton's cases. We've got clause numbers 25 DCCR 0907, 1446, 1467, and 1468. Ms. Mouton was examined for competency to stand trial by Dr. Capon. I have received that report dated September 29th of 2025. And the finding in that report is that Ms. Mouton is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Rojas?
No, Your Honor.
Mr. Smith? Then at this time, based on that report, I am going to find Ms. Mouton competent to stand trial. And Mr. Rojas, what is the announcement then?
Judge, can we get one more announcement? I'm gonna need some time to go over the rest of the discovery with Ms. Mouton.
Sure, we'll just do a normal reset. Ms. Mouton, Mr. Rojas will be out there to go over everything that he has received, and then you guys can make a decision on what you want to do with your cases, okay? You can go back with the bailiff.
Thank you.
Yes, sir, thank you.
Barbara, thank you for the $5 for Ellie for catnip. Ellie loves catnip. Io not so much. She could care less, but Ellie loves a good catnip high. We did a little research on it. It's actually about 30% of cats actually have no reaction to it. It's how it binds with certain receptors in your brain. But Ellie all about it. Io not so much. But thank you, very much appreciate it.
Good morning, are you Kevin Damon Ross?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor, there's two, I believe, two MTRPs and.
One new case. Okay, so he'll waive the reading of the motion as well.
We're gonna enter proofs of true count one, which is the new case allegation, and then there's an agreement on all three.
All right, let me let's go forward with the new case first.
We're asking for an updated PSI.
Thank you, please.
And Judge, if you need, excuse me, more than that, all of the other counts stem from the sole incident. I think the court has reviewed the video previously of the evading. You'll recall we had an agreement of 5 a while back. The court rejected that, understandably, just because we're doing an update. If you need more.
I don't remember the video. You have to tell me more, but
It was a very high speed evade through multiple areas of the county with the DPS.
okay. While on probation for evading. Yeah, I remember now. And what was the agreement that I had rejected before? Okay. All right, sir. In cause number 25, DCCR 1310, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from June 13th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? I have here, in that case, some documents on the tablet that have your signature on them. Before you signed these, did you go over them with Mr. Burbank? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 8 years in prison, which means you're leaving your punishment up to me. And if I follow this agreement, I cannot give you more than 8 years. I can give you 8 years, I can give you less. It'll all depend on the information that's presented to me when we come back for sentencing. You have an absolute right to have a jury come in and do 2 things. The first is to determine if you're guilty or not. And then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that right. And is that what you want to do? Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Is there any evidence that Mr. Ross is not competent? right, sir, in that case, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and we'll come back later for sentencing. Obviously, anything that you think is important for me to know, you'll get that information to Mr. Burbank, and he'll present it to me on that day as well. So then we have cause numbers 24 DCCR 1198 and 24 DCCR 1199. Each of these cases, I have motion to revoke unadjudicated probations. It looks like in 1198, you were placed on probation December 18th of 2024 for the offense of deadly weapon in a penal institution, a third-degree felony, and that was a 4-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 24 DCCR 1199, I also have that motion to revoke your unadjudicated probation. Shows you were placed on probation that same day in December of 2024 for the third-degree felony offense of evading arrest or detention with the use of a motor vehicle. Is that also correct?
Yes, ma'am.
So if it's unagreed, somewhat unagreed, I want to go ahead and go through the rest of those allegations. I think I need to know if the punishment's up to me, what the pleas are, what all's been going on, not just the one new case. So I'm going to go through them all. If you need a minute to go over that with him, otherwise I'll just go through. So, Mr. Ross, both of these motions allege in count 1 that you were arrested for the offense of evading arrest or detention with the use of a vehicle on June 13th of 2025. That's the case you just pled guilty to. And is that true or not true?
Yes, ma'am. Sure.
And that's one of those, Ms. Malfino, that probably needs to be looked at. Being arrested for it isn't really it's true, it's fine, but that language, y'all need to get them to change that language.
Okay.
You know what I mean?
I do.
Count 2 alleges that you were arrested for evading arrest or detention. That was that same day. Is that true or not true? So that's not in the vehicle. That means that you got out of the vehicle and then ran. Is that true or not true?
Sure.
Count 3 in each case alleges that you were arrested for possession of marijuana June 13th of 2025, that same day. Is that true or not true? Okay. Count 4 in each case alleges that you possessed marijuana in violation of your probation order on that same day. Is that true or not true? Okay. Count 5 alleges that you tested positive for cocaine on a drug patch June 13th of 2025, and is that true or not true?
Not sure.
Count 6 alleges that you were at a location other than your residence at approximately 1:39 a.m. on June 13th of 2025. That's true?
Yes, ma'am.
And then count 7 in each case alleges that you're a little behind in your court assessed fees in each case. Is that true or not true? Did you enter your pleas of true in each of your cases to counts 1, 2, 6, and 7 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
All right, then I'm going to find in each of your cases that, in these cases also, I have here on the tablet some documents that have your signature on them. Did you also go over these with Mr. Burbank?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And again, you understand if I follow any agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal.
Yes, ma'am.
And are these just no agreements, just to run concurrently?
Well, no, there's a cap of 8 on those.
Y'all didn't write that on here.
I thought I did.
All right, or it might not have come through. So so cap of 8 in each.
Yeah.
So the agreement is the same as the other case,
Yes.
that I can sentence you up to 8 years in prison or less, depending on the information that's brought to me in a hearing. You understand?
Yes, ma'am.
State tenders number 1 in each of those
No
cases.
objection, states 1 in each case.
It's admitted in those cases. Mr. Ross, I'm going to find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence in each of your cases to find you guilty and revoke your probations. However, I'm not going to do that today. I'm going to reset your cases for sentencing. We'll get the probation department to do updated reports, and then, again, anything that's important for me to know, get that information to Mr. Burbank, and he'll present it to me on your behalf when we come back. And if there's anything of those that are, you feel like proven up at that time, I think it's just mainly the drug patch and that possession of marijuana, but
Okay,
either
I'll
way.
have the probation officer here, Judge, but would you like to hear from that trooper? He's been relocated.
No, I think we're good with the others. So, Mr. Ross, I also, before you go back with the bailiff, I have in my hand jail incident reports. So if you're gonna come in here and ask me to do something other than 8 years in prison and give you some kind of circumstances good, it's not gonna happen. The names you are calling these correctional officers, the rules that you're breaking, the gambling with the I mean, it's not allowed. If you can't follow the rules in jail, then what makes you think that I'm going to do anything nice for you? If you call people,
With the last one,
don't even, y'all talk to Mr. Burbank about it, okay? But the name calling, you know what I'm talking about, right? Okay. I don't care what they're doing their job, right? So they're going to work every day, they're going home, which is hopefully at some point what you would like to do in your life. Get a job, go home, be with your family. And if you had someone like you acting like that at your job, when you're just trying to do your job and enforce the rules, you're in jail. You got to follow the rules. You don't want to follow those rules, then stop committing felonies. All right, go back with the bailiff. We'll see you at sentencing. Yes, sir. I almost said the words.
All right, time to switch it up a little bit. Let's stay in the building, but we'll go across the hall to Judge Stevens.
CR 1089, the state of Texas versus Gerardo Galvin. You are Mr. Galvin?
Was it done on today's day?
Yes.
This is a plea, Judge.
Oh, it's not a plea. Oh, this you were saying you were working on a plea for us. What are we going to do on this?
Well,
It's an announcement.
Judge, I spoke with defense counsel. He stated that he had made an agreement with the prior prosecutor that I'm not aware of, so I need to check into that and see
Okay,
if
how much time? 3 weeks going to be good enough, you think, to figure it out?
that's perfect on my
What
part.
do you want? You tell me, what do you?
More like about 30 minutes, but.
Oh, that's all you need?
Well, I don't want to do that to her. This case is getting old. And it's one that needs to. I'm trying to, I mean, which one?
If we can hold,
Yeah.
I need to check,
Yeah,
I need to check
Get
with
back
my,
with me.
yes, sir.
I'm
If
here.
it's okay.
I'll be
Yeah, thank you.
playing this venue all day. Okay. All right, short recess. We'll be back in a few minutes. Thank you.
All right, he stepped away, and they need another contestant anyways. Let's go to Louisiana, see what's going on with the board.
Are Mr. Chuck Tillis and Ms. Gerald Ledoux will be joining us by Zoom. I'm located at DOC headquarters staff. Will you please introduce yourself for the record?
Jason Thompson.
Then Cavalier.
Carla Williams. Okay. Today, our remote location is Point Capee Parish Jail. Is there any staff in the room? And if so, will they please introduce themselves? Any staff in the room? Can you hear me, sir? Yes. Will you please?
Can you hear me now?
Yeah, I can, yes.
Corporal Frank here with the Point Coupee Parish Sheriff's Office.
All right, all right. Mr. Cavalier, will you please introduce yourself for the record, please?
Kyle Jude Cavalier,
And your DOC number?
773-424.
Okay. Do you have a questionnaire that they gave you and that you signed?
Yes, ma'am.
All right. Let's see, it says that, well, according to this, you're not eligible for appointed counsel. And, do you want to proceed without counsel?
Yes, ma'am.
Okay, thank you. All right. The lead person has been assigned to your case is myself, and I will review your violations, and you may answer guilty or not guilty with or without a statement. Today, you're going to have in opposition, Michael Conrad from the, Point Coupee Sheriff's Office, and he's going to speak also. All right, so you're, get to you. Here we go. Okay. You're going to answer guilty or not guilty, okay, with or without a statement. First of all, number 4, you were involved in criminal activity on 10/21/2025 through the commission of the offense of battery of a police officer while being taken into custody by the Point Coupee Sheriff's Office. You were being taken into custody on an active bench warrant issued by the 18th JDC due to failure to appear to a pending misdemeanor charge. You were booked into the Point Coupee Detention Center on 10/21/2025. You were arraigned on 12/16/2025 before Judge Kimball of the 18th JDC in Point Coupee Parish. You were billed with 2 counts of battery on a police officer in which you were sentenced to serve 6 months on each count consecutively with credit for time served for the date of arrest. All other pending charges in Point Coupee were not processed this date. Do you plead guilty or not guilty?
Not guilty.
All right. Do you have a statement about that?
No, ma'am.
Just that you didn't do it. Okay. The second one is number 10. You failed to submit payments towards your supervision's fees and are currently in arrears of the amount of $504. Guilty or not guilty?
Guilty.
Okay. All right. At this point, we're going to have opposition speak. It would be Michael Conrad from the Point Coupee Sheriff's Office. You can just go to the podium. Yeah, that. Okay. How do you do, sir?
I'm fine. You?
Fine. You go ahead and tell us what happened.
Okay, so the night of this incident, we were actually looking for his other charges and warrants. He happened to be at the residence and was found to have a warrant for his arrest as well. So he was taken into custody. As soon as he was taken into custody, immediately began just acting off cussing, hollering, threatening. Once he was forced into the patrol unit, almost had to be drugged into the patrol unit. He was so irate, cussing, yelling, spitting all over the place. I warned him, I believe, twice. If I'd have had looked, I know it's out of their control, but if I'd had a little bit more better earlier of a notice, I could have got the body camera footage as well. But I warned him twice about the spitting, and he continued. And that's what he was charged, that's why he was charged with that. He was, he had that warrant, due to, that failure to appear. I think that was for theft, and just previously, just a month or two earlier from that, he ran from us, from a traffic stop. He bailed out of the car, and had to be, tracked down and called as well.
Okay. All right, so, that concludes your statement, sir.
Yeah, I mean, if I can get my opinion, I mean, it's a nuisance to the community. He's always been, towards law enforcement, non-compliant, in and out of trouble, in and out of jail, no respect for nothing. Family covers up whereabouts and stuff when he had been looked for. I just, think you should sit where he's at in the times of.
Okay, thank you for coming today, sir. So at this time, we're gonna take questions, from the board members. And, Ms. Ledoux is on Zoom, so I'm gonna go ahead and start off with her and see if she has any questions.
No, I recognize he has been charged and sentenced for those misdemeanor crimes. So,
All right, and Mr. Hillis?
Mr. Cowell, were you on drugs at the time?
Yes, sir.
You were using drugs? Okay. And what got me was you pled not guilty to condition number 4, so, and you don't want to elaborate on it?
I really don't know what happened. That's why I pled not guilty.
Oh, okay, I see. All right. I have no more questions.
Okay. I don't have any questions. Like you said, you pled not guilty because you couldn't remember because you were on drugs, so you already violated. You just admitted to violating your parole. You're not supposed to do any kind of illegal drugs or so. Is everyone ready to vote?
I am.
Ms. Ledoux?
yes.
Okay. I'm the lead on this investigation, so I'm gonna vote to revoke your parole. And the reasons is because you had an active warrant against you, so you'd already broken the law. The battery on the police officer also, and then you just now admitted to partaking in illegal drugs. Next. Ms. Ledoux?
Yes, my vote is to revoke based on non-compliance with conditions of parole and that he was sentenced for misdemeanor crimes.
Okay, and Mr.
My vote also is to concur with my colleagues.
Okay, so you've been revoked today, sir, and the time is 9:01.
All right, can I ask a question?
No, you may not. All right, revoked to the surprise of nobody, I would suppose. Let's rotate back to Judge Stevens, new contestant.
25 CR 1137, State of Texas versus Claiborne Livings. You or Mr. Livings, and you were present here with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about August 7th, 2025, in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you are charged with in this indictment, sir? You have to speak out.
Yes, sir.
So you can hear. Okay. Okay, there's an agreement that's been reached where you're going to be pleading guilty to a lesser included offense of what?
Criminal trespass, Judge.
Yeah. Okay, there's not a doubt that that's, I see assault, a lesser included assault is in here, but that's going to be,
Intentionally knowingly enter a habitation without the consent of the owner, that is criminal trespass, Judge.
and that is Class B misdemeanors.
Correct, Judge.
Yes. Yeah.
What's the word on getting new pads?
No, I was just thinking about that this morning, Judge. I have not heard recently, so I will double check on that this afternoon.
These babies, you write and it doesn't show up on the pad until about 10 seconds after you've hit it. Which, right, agreement has been reached by the parties where you would be prosecuted and you would move forward on a plea of guilty to the lesser included Class B misdemeanor of criminal trespassing, which carries with it up to 180 days in the county jail and a fine up to how much on a Class B? $2,000. Is this your understanding of the plan? And do you understand fully the punishment range you are facing here for this lesser included misdemeanor? Speak up so she can hear. Yes?
Yes.
How do you plead to this lesser included Class B misdemeanor, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
And without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been wrote to you. You've read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
I'm going to follow this agreement, if nothing further to add, and find that Mr. Livings, you are mentally competent to enter this guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this hearing here to find you guilty beyond a reasonable doubt. But we are going to defer any finding of guilt. How long can I place up to deferred on Class B misdemeanor?
Actually, Judge, I need to correct myself. It's a Class A misdemeanor because it's a habitation. And with any misdemeanor, the court has the authority to go up to 2 years.
All right, we're going to have to backdate everything here and go back to this. Sorry, this is a Class A misdemeanor, not a Class B misdemeanor. That's got to be corrected. Which carries with it up to 1 year in the county jail and a fine up to $4,000 can be assessed. Do you understand that punishment range, sir?
Yes, sir.
That's what you're facing, not the Class B that we talked about. Do you still insist on making your plea of guilty in this case based upon what the court has stated to you?
Yes.
All right. Then I'm going to follow this agreement and find the defendant is pleaded guilty again, voluntarily, knowingly, intelligently to this Class A misdemeanor, lesser included offense of criminal trespass. Even though there's enough evidence to find you guilty beyond a reasonable doubt from this hearing, the court is going to instead defer any finding of guilt and place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will have no contact with the victim in this case. So I don't know what the underlying circumstances
I would
here.
I would agree that that's appropriate, Judge.
How did you know this person?
It was my sister's best friend's mom's boyfriend.
I'd have to have a roadmap to follow that one. That's 4 degrees of distance from a direct relationship, though. Nonetheless, is all that being fixed
Yeah, yes, sir.
responsibly and legally?
Yes, sir.
Okay. Make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in the county jail. Okay. Please see this lady. Thank you very much.
Sorry about the mistake, Judge.
It's okay. Judge, Mr. Walker, you got.
Judge.
You don't go ahead.
I think y'all can work together.
To be honest, after that, the only thing in my mind is the classic movie Ferris Bueller, where I forget, Simone, I believe is her name in the classroom, says that my best friend's sister's boyfriend's cousin's girlfriend heard from this guy who goes with this kid who knows this girl who saw Ferris pass out at 31 Flavors last night. I'm pretty sure that's how that went. Back to Judge.
Yes, sir. Oh, okay. Sure. All right. This is there was an attempt to try to resolve this.
I think it's news to him, Judge, and I'm in shock right now. I'm going to explain it to him. When
okay. It'll be set for trial. If y'all change your mind, let me know on how we dispose it. But otherwise, like you say, it's almost 2 years old. It needs to move forward one way or the other. Okay. Please get a reset.
Thank you.
Thank you. Yes, sir. Otis Pollard.
He's here.
Two cases. You're Mr. Pollard? Yes, sir. Pollard?
Yes, sir.
The accent is on the first syllable. All right, you're charged with 3rd-degree felony of unlawful possession of a firearm by a felon in 25 CR 138 and in 25 CR 139. That indictment alleges that you committed the state jail felony of theft. So you were looking at up to 10 years in prison in one case and up to 2 years in state jail on the other. So that's serious. What are we going to do?
Just gonna have just one more announcement on him, and I'll be ready. Just one.
How much time is that?
The normal, whatever your normal is.
Well, you're in the criminal district court. There is no normal in this building, in this room, as you know. Is 4 weeks good?
That's cool.
Oh, good. Thanks. Chastity Rashton. Get a resetting.
That's going to be disposed of. I think the state is taking care of that.
This is going to be refiled to a misdemeanor.
Okay, there isn't a lesser included we can do on this?
No, Your Honor. Not with the way that it's alleged in the indictment.
Yes.
Okay.
We'll do 1 week. They give them time to do it. That's enough time.
Oh, this is just a review. You're going to end up doing it in misdemeanor court, right?
That's fine.
Is that right?
Yeah. We would just need to place this on a docket for dismissal once the misdemeanor is pled to.
What we're going to do is just put it on a review docket in 2 weeks.
That's fine.
2 weeks, we can know it's going to be done.
Thank you.
Thank you. And Paris Ross.
That's sentencing.
Get a resetting, lady, madam, right there. Thank you.
And just in sentencing now, I have just 2 character witnesses, his mother and his sister, and it's not going to be long. But he's here, and that's Mr. Ross, and then his mom and his sister is to the left and the right. Just come on the first row. And this is sentencing. We did review the PSI too.
On the highlighted up one, please.
All right, we call two cases. 25 CR 381. You are Paris Ross. Sir. And you are charged in 381 with fraudulent possession or use of a credit card. And that is a second degree felony, which carries with it up to 10 years in prison, 20 years in prison. I'm sorry. I was looking ahead. You are charged also with 25 CR 382, the third degree felony of forgery of a financial instrument. And that carries with it up to 10 years in prison. And it's like these were committed on or about the same date in October of 2023. He hadn't entered his pleas yet.
He did.
Yes, he
He
did.
already did? Okay.
Mm-hmm.
Because it
December 3rd, Judge.
And we got the PSI.
All right, a pre-sentence report has been prepared on each of these cases. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
Yes, sir.
Go ahead.
The first correction is on page 1. And
which?
And that's defendant's version. And under defendant's version, where it has on here about denied participating in the offense, that's a correction for us because he's saying that he admitted to the offense, so that's a correction. And then the other correction I think would be on page 5.
Hold on, let's deal with that. First one.
That's on page 1, and that would be under defendant's version where it had denied participating in offense.
He admitted. Okay, this is line 5 under defendant's version.
Yes, sir.
Well, we got to go up some too, because he claimed in line 4 of defendant's version, the defendant claimed ownership of the items to prevent a female he was dating from getting into trouble. He goes on to state he admitted he was aware the items were connected to fraudulent activity, but denied participating in the offenses. He further stated he has learned not to take on other people's problems and not to place himself in harmful situations, and that his outlook on life has changed since the birth of his newborn child. So you're skipping around responsibility. You're either guilty or not guilty.
I take responsibility, Your Honor.
Is that your final answer?
Yes, sir.
He's going to want to correct page 5, 1, 2, 3, third paragraph, beginning in factors. And the correction for that third paragraph that begins with factors warranted, where it says maintaining that he did not commit the offense while acknowledging that he was aware of the illegal activity taking place. He's saying that he does take responsibility for the offense. So he wants to correct that sentence in the PSI.
Can he correct what is the recommendation of the pre-sentence investigation?
No, he can't correct that. He can only correct what he is.
That's what he's proposing with that last suggestion, Judge. And I would believe that Ms. Carthen is only responding to what occurred to her personally. And since I wasn't there and Mr. Adams wasn't there, I don't know how we can correct that.
Taking one problem at a time here.
Yes, sir.
The defendant admits responsibility to each of these two offenses for which he has pleaded guilty to.
Yes, sir.
That's your final answer, correct?
Yes, sir.
Okay. All right. And denying participating in the offenses, why would you say that? Were you confused or something?
No, sir.
You were being dishonest with him? With the probation office? You denied participating in the offense is what you told the probation office.
Yes, Your Honor. I was in assumption like they was thinking that we used it or did anything with it. We didn't.
Okay. You've talked to your attorney about the elements of this crime, what constitutes each of these crimes, and you either acted as a party legally to this or you were solely responsible. Is
Yes,
that
sir.
correct?
Yes, sir.
Okay, in each of these two cases.
Yes, sir.
All right. What was the second part?
That was the only other question.
No, the second part that Mr. Ham has an issue with.
No, I was just trying to correct page 5.
I'm trying to change the comments under the recommendations on page 5, third paragraph down. He's suggesting that the last sentence be altered because of the change in his position today.
This thing, you mean where he did not accept responsibility?
Yes,
Yes,
sir.
sir. Where it says maintaining that he did not commit the offense, acknowledging, blah, blah, blah. I'm asking that that be corrected because he's saying that he did accept responsibility. So that was a correction because you had asked me if we had any corrections.
Okay. Well, as far as this court's concerned, it's never too late to accept responsibility for culpability in a crime unless it's too late after the judgment has been entered. But if he wants to correct something, the court will consider it and allow it because what we're trying to get to is what is the truth?
Yes, sir.
Is that the truth?
Yes, sir. I take full responsibility.
All right, there's an agreement that's been reached here where for each case, a cap of 4 years in prison. I guess they'll run concurrently.
Yes, sir.
All right. So we are looking at no less than 2 nor more than 4 years in prison.
Yes, sir.
We are looking at up to 4 years in prison and then found guilty, and then he could be placed on regular probation for up to 10 years.
Yes, sir.
And then there's deferred or unadjudicated probation.
Yes, sir.
Which this court can assess, which would be up to 10 years, can be up to 10 years in length. Are there any other options the lawyers can think about here in disposition?
That's it.
All right. I want to ask you about this. Were there any other issues to be dealt with the proposed pre-sentence report?
That was the main thing that I saw that I wanted to correct. Other than that, I didn't really see too many other corrections.
From the state?
None from the state, Judge.
All right. I want to get a grip on one thing, criminal history here. Anybody figure out exactly how many convictions he has here? Because it's a little nebulous as I'm reading this, and it's not the probation officer's fault. It's just the defendant has been busy making bad mistakes for a long time, since 2008, actually, according to this. So we're talking about
I think if I'm-
15, 16 years.
I thought, Judge, you were going to go to the misdemeanor that purportedly received a 12-year probation period, which I don't think is viable.
Okay, we start off, we're going to start from the beginning of issues on page 2. On July 2nd, 2009, it states the defendant was convicted and sentenced to 12 months probation for driving without a valid license. Is that true? That was out of Fulton County, Georgia.
Yes, sir.
Okay.
2009.
Yes, sir. But it says it runs concurrent with the prior sentence. I don't see another prior sentence in the misdemeanor court history, but I do see one, armed robbery. In 2008, you were convicted, 1 year confinement, 9 years adjudicated probation. So that must be what they're talking about. Those two, the misdemeanor ran with that felony, I guess. Also, you had a hindering apprehension or punishment of a criminal in Fulton County, Georgia, also on September 25th, 2008, and were sentenced to 1 year confinement, probated for 4 years. And that all occurred about a year before you were convicted of that misdemeanor. Then thereafter, that misdemeanor conviction and your 2 prior felonies of armed robbery and hindering apprehension, it looks like you were convicted November 2009, 7 years probation for burglary. That was revoked and you were sentenced to 3 years in prison in 2016. That true?
Yes, sir.
And also on November 25th, 2009, you were convicted and sentenced to 7 years probation, which was revoked, and you received 3 years imprisonment on the same date the burglary revocation and imprisonment occurred. And on this one, it was illegal possession of tools for the commission of a crime. I guess burglary tools, I guess. That was revoked and you were sentenced to 3 years as well to run, I guess, concurrent with the burglary. Then kind of backing up a space. In July of 2009, you were convicted and sentenced to 5 years probation for theft of receiving stolen property. Is that true?
Yes, sir.
So that means 1, 2, 3, 4, 5 felony convictions as of 2009 and 1 misdemeanor. But then in 2016, you're convicted of 3 forgeries, sentenced to 90 days confinement to run concurrently. And I don't understand, that is under felony history, but was that a felony or were those felonies or misdemeanors? Does anybody know? He's asking 90 days confinement. I mean, that would be a misdemeanor in Texas, but then 2021, you're sentenced to 6 months confinement. And that was adjudicated for 2 years probation for selling, giving, or transporting marijuana out of California. Is that true?
Yes, sir.
And in 2023, which would have been in June, you were sentenced to 15 days confinement for evading arrest or detention with a motor vehicle out of Harris County, Texas. Those are some of these are coming up under the adult felony history, and that might not be right.
My NCIC report indicates that the South Carolina offenses are felonies.
Only about
the ones that he received 90
Harris
days.
County and California.
Okay, so the question,
Oh, wow.
sorry, I was trying to answer for Your Honor, is there were 3 convictions in 2016 where we received
Right
90
out of
days.
South Carolina.
Those are all felonies according to the NCIC.
And
I'll
then
check the Harris County on that report.
and we've got to round out the field here, 2 more convictions which are listed as misdemeanors. One in 2023 out of Harris County, Texas. You were convicted, sentenced to 3 days for assault of a family member. And then,
All right, Judge, I'm sorry, but Harris County,
yeah,
the original offense of evading detention was apparently pled as an eluding. So that should not be a felony. It should be a misdemeanor. That's the last one that has an offense date of June 2nd, 23.
okay.
And I'll check.
Say that again now. What did
The evading arrest detention with vehicle that was offense date 12/17/20
yes,
was disposed of on June 2nd, 23 as a misdemeanor offense of fleeing a police officer or eluding, as I like to call it. That is why it's a 15-day sentence there.
Okay.
And
that makes sense.
I will check the California.
Okay. We've got I'm doing this in a chronological sequence. He's convicted in January of 23, 3 days confinement out of Harris County. That's a misdemeanor in Harris County, Texas. Then finally, he was convicted and sentenced to 13 days confinement for theft by conversion out of DeKalb County, Georgia. And that was a conviction on February 2024, but yet it states the date of offense is a decade before that happened. See, it states the date of offense was June 2015, and he was convicted 9 years later. That's weird, too.
That's Georgia's history, Your Honor. Is that correct? Is that what I'm looking at?
Mm-hmm. All right. So. We add all this up. We've got a total number of convictions here of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Is that about right? 4 of which are misdemeanors that we know are misdemeanors. Others are apparently felonies.
The California case is a felony. I confirmed that through NCIC, Judge.
Okay. Here, each of these 2 cases occurred on that we are dealing with the sentencing on, the forgery and the fraudulent use of credit or debit card, third degree and a second degree respectively. Is this event, each of these events allegedly occurred in Jefferson County on or about October 19th, 2023. Which would have been just a few months after he was convicted and sentenced out of Harris County for that evading arrest or detention on June 2nd of 2023.
I did confirm, Your Honor, from NCIC that 9-year time frame on the Georgia offense is accurate. He had a warrant outstanding during that time frame for not appearing and finally dealt with it in 24.
Okay. All right, anything else anyone needs to change about in this pre-sentence report, especially under the police court version, defendant's version, or any other parts of the criminal history? Yes, no?
No.
No from the defense, no from the state?
No, no.
All right. Go ahead. Again, the agreement reached is whatever sentence shall not exceed a cap of 4 years in prison.
Okay, look, I need one to cook. I'll be brief with you.
Okay, you want to
I just
present something first?
Yes, sir.
Who do you call?
Ms. Cook, would you state your full name for the record?
LaWanda Baggett Cook.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Lower your hand. Go ahead.
All right, Ms. Cook, you currently live in Georgia, right?
Yes, I do.
And your son lives in Georgia, right?
Correct.
Who's your son?
Paris Ross.
Oh, okay. So we don't know.
Oh.
We're just learning. I don't know your family situation. The defendant is your son.
Yes, he is.
Okay. Good.
No.
Repeat that for me.
Would you spell your name for me?
LaWanda, LaWanda. Maiden name is Baggett, B as in boy, Aggett. Married name Cook, Cooke.
Right. So, as I was saying, you're my client's mother, right?
That's correct.
All right. And you understand with the plea bargaining agreement today, he's been charged with 2 offenses, the fraudulent use of credit and debit card abuse, as well as the forgery of the financial instrument, right?
Correct.
And you understand that the plea agreement is a cap of 4 years where the judge could consider probation, right?
Correct.
All right. So to get straight to the point, you're familiar with your son's criminal history, aren't you?
Learning, yeah.
Right. And you familiar with his character and who he is, right?
I am.
All right. The reason I brought you up here is that your son is your special caretaker, isn't he?
He is.
And I know it's hard for you to, talk about that, but you have a very serious ailment right now, right?
Correct.
And what is that serious ailment that you have right now?
I'm dealing with stage 4 cancer.
So you're dealing with stage 4 cancer, is that right?
Correct.
And with that being stage 4 cancer, your doctor has basically diagnosed you as dying, right?
He told me to live my best life.
Live your best life. Well, I mean, I'm just saying.
He said to go live my best life.
Live left, right.
Well, I mean, that pretty much takes a lot of hope out of things, but.
No, I'm just saying.
But
I'll explain why. And with you going through.
So you are being treated
I am.
medically?
Yes.
Okay. How long have you been experiencing this ailment?
I've been sick the past 5 years, December 13th, 2020.
Yes, ma'am. Okay.
So with you being in Georgia and with the stage 4 cancer that you have, is your son a provider for you?
He's the main provider.
And by the main provider, how is he the main provider?
He's making sure the bills get paid, making sure I get my medication, making sure I get to my appointments.
So at the end of the day, we know about his history. We know about the offenses that are charged. Are you begging the court for mercy today?
I am.
And are you asking the court to put him on probation today?
Yes. Yes, I am.
And without me putting words into your mouth, I want you to speak to the judge in your own words and tell the judge why you want probation for your son.
Good morning, Judge. My name is LaWanda Baggett Cook. I'm the mother of Paris Jawan Ross. I am dealing with stage 4 cancer. They just removed 10 mass out of my body, 7 out of my chest, 2 out of my diaphragm, and 1 out of the upper right lobe of my lung.
When did you become aware you had an illness? When did the illness begin? Do you remember?
Well, it went from COVID cancer, but I just had surgery May 7th of 25.
You said it happened during COVID?
Yes.
So in 2020? Again?
December 13th, 2020.
Okay.
And Harris is my, not only is he my caregiver, he's my power of attorney. He have all the final rights and know my wishes once God decides it's my time. But I'm a single mom and clearly don't have any other person in my life significant otherwise. Not really able to work. And a lot of times can't even get up and cook and take care of myself. So he is my main source. He is, and I'm asking for mercy of the court.
So basically for you, a day in your life, you deal with the treatment of cancer, right?
Treatment, pain, sickness. I could be well right now and a little bit later, balled up in the bed. So
right. So you can be balled up in the bed in excruciating pain.
Yes.
And agony, right?
Yes.
And while you're in this pain, what does Paris do?
Well, when he's home from work, he's the person that prepares the meals. He will bathe me. He will even change me or get me to the bathroom if I need it. He's good with that. He's real good. But he'll send food to the door through Uber Eats when he can't. If he's at work, he makes sure some food is coming to that door for me. Food, water, anything that I need. He's the person. He's my carrier, 100%.
So here's the last question, and I'll stop. I'm probably the judge and the prosecutor's gonna have some questions for you.
Okay.
But at the end of the day, we're familiar with his criminal history, right?
Mm-hmm.
We're familiar with the current offenses, right?
Correct.
But at the end of the day, you need him for survival, don't you?
Yes, I do.
And with that being said, are you asking for the court not necessarily to look at him, but let's look to you as someone who's needed, right?
Yes.
And are you begging again the court for its mercy?
Yes, I am.
By allowing him to have probation in spite of some of the things that he's done.
Correct. That is correct.
Thank you for your time.
Thank you.
Do you know why it took him 9 years to resolve that case in DeKalb County, Georgia? That's where you live, right?
That is correct. I have no clue how why that took so long.
I mean,
I need to remember if I can remember it.
if he's the one that's responsible for helping you out, like we were talking about, you would think he'd take care of this a lot quicker than that, right?
I imagine.
Yeah. I was just wondering. Thank you, man.
Anything else?
No, yeah, not from her.
A couple of issues I want to address on this. Number one, I heard what your mother has said, and yet with her illness, yet you're supposed to be taken care of. You committed after she was diagnosed and you knew she was sick. You committed, let's see, 4 different crimes and were convicted of 4 different crimes. And yet you knew she was seriously ill. And we're talking about in DeKalb County, Harris County, San Mateo County. So this is across the country, in Georgia, California, and in Texas. Also, you have 9 siblings, don't you? 9 brothers and sisters.
3 of them, well, 2 of them.
9 brothers and sisters.
Yes, sir.
That's what the probation officer wrote because you told her that.
Yes, sir.
Is that right?
Yes, sir.
Where the heck are they? You've got 9 siblings. Aren't they supposed to be doing their part to help this lady? Or have you been abandoned by all 8 of your children?
They're not mine, they're from his dad.
No, that's not what this says. Reported to have 9 siblings shared between his mother and father.
I got 2 of her, the rest of with my dad.
This says 9 siblings shared between his mother and father. That's what the probation office wrote. I know what that means. It's English. You have 9 brothers and sisters by her and a father.
That's correct.
Well, where are they? Why aren't they helping? The only person who's helping is the person who has committed. How many crimes did we talk about?
You said 13, sir.
Yeah, 13. But the criminal, the consistent criminal, is the only one of the 9 who is able to take care of you, but yet he keeps committing crimes while you are seriously ill. What kind of responsibility is that? Pathetic. Well, you can't lever your mother's illness as a method of keeping you from being held responsible for committing 13 crimes and another one here before this court. I mean, how can it's like I'll keep committing crimes and I'll use my mother's illness as a get out of jail free card?
No, sir.
No, that's what's being said here. You have 9 siblings. They need to be doing their part naturally, decently, Christianity-like way. It's a moral thing to do. Where are they? Or have they all abandoned you, man?
2 of them have not.
2 haven't. Well, then they're going to have to take care of you because he's going to prison. And he's got to be held accountable. And with his rich criminal history, his lawyer has somehow fashioned a remarkable limit of his exposure for criminality. Because after all of these convictions and committing now 2 more convictions, crimes, which are similar in nature of dishonesty, these one of these is a 20-year possible sentence. The other is 10. He was looking at 30 years in prison. And these are the kinds of cases with a rich criminal history like you have that get stacked on top of each other. But he has fashioned a deal of a cap of 4 years in prison, which is pretty good arrangement. Is there any restitution here?
No, Your Honor.
Okay.
None, despite all those cards that I've shown one.
My mother's still alive. I just saw her yesterday, and I couldn't imagine hurting her in any way. But your choices that you make, you just don't hurt you. There's the lady who seems like a wonderful person. My goodness, nature has dealt some difficulties. And instead of being the good son, not only to help her, but to make her proud, you continue to make the same kind of mistakes you've made for going on, well, since 2009. Today is 2009. 2008, sorry. 16 years? 17 years? Going on 18 years of criminality. And your mother's needs you. So quite naturally, you continue to commit crimes in 3 different states. Okay. I don't feel sorry for you. I feel sorry for us. And yeah, you need to work on a whole lot, not only your own choices, but you need to quit putting yourself first. It was the great book Gail Sayers wrote, I am third. The supreme being is first, others are second, I come in third. That's why he's great. He has a great message. You need to read that book because you keep putting yourself first when others should be placed ahead of them. You should be doing better work for others, the decent thing, taking care of family needs. Anything else to add? Anything else you would like to add, sir?
Judge, if prison is going to be in, Judge, I would ask that on 4-year cap that you do 2 without having any definitiveness to his mother's condition. At least I think that would at least give him a chance to get out and to still be with her in her final days. And
okay, I'm sorry. Go ahead.
That's why I was asking for the. I was asking for that number.
I can't help but say that's not the way sentences and the justice system and the laws are supposed to work. Essentially, it's the circumstances of the offense and criminal history. He has dealt with his mother's condition for several years, and yet that has not deterred him. I'm worried about the community at large being subject to more criminality. His mother's illness and her need of him to help her. He has elected to continue to commit crimes of dishonesty, among other things, than do the right thing morally and decently. And the community is best served overall for everyone. Even though your mother needs you help, you should have been helping her when you were committing these crimes, when you knew she needed help. Shame on you. If nothing further by any party, I'm going to find you have pleaded guilty in each of these 2 cases, sir, in 25 CR 381 and 382, illegal possession and use of credit or debit card abuse, and a 2nd-degree felony, and the 3rd-degree felony of forgery of financial instrument. You have pleaded guilty in each of these felonies voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. I am following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. These 2 sentences shall run concurrently. And I hope that your mother is able to get the help that she needs from other members of the family, the 8 other siblings, because you have failed her responsibly. You have failed the by failing to follow the rules of law and by continuing to victimize other people. Shame on you. And I wish the very best for her. I know reared you better than you have acted over these 13 convictions for 20 some odd years. Anything else to add? That is all we are in recess on this case. Thank you. Here's this.
Thank you, Judge.
Isn't that sweet? He gave her a kiss before he got let off. I have so much to say. Welcome to the 4th hour, also known as TCF Overtime. Good to have you all here. If you want to sound off on anything we've seen here today or anything else, as long as it's at least somewhat law-related, and you're a channel member, go to the Discord under the member announcements section, and you'll find a link to join me here today for the 4th hour. Couple of things. First off, Stevens announced a new word that I wasn't aware of, and that's Christianically. I feel like that should be merch. He comes up with some interesting stuff sometimes. Hadn't heard that one before. And he said at the end that, something to the effect, I'm paraphrasing, but something to the effect of your mom raised you better than that. No, clearly not. People make their own choices for sure, but something went wrong in the upbringing of that person that he turned into this. And some of that is on her. And I'm not trying to, sit here and just pile on a woman who's dying of cancer. That's sad, but two things can be true at once. She can be dying of cancer, and she could have raised a bad child. Clearly, she raised a bad child. She's got some hand in what happened here today, either through her actions or through the omission of actions. Barbara says in the chat, no father present. That's also a problem, but also, at least in part, it has to be on her because she either chose the wrong man or she failed to keep a good man in the house or something. I don't know, but there's a failure. She's partially responsible, and that leads to part of what we had today. So with those couple of things said, I made 3 different points that I want to go through regarding this case. And then afterwards, I actually have 2 court-related stories out of the Dallas-Fort Worth area that I wanted to dig into here in this 4th hour that aren't things that we've covered here on the channel, but I find them interesting and worth talking about. And again, if you want to join me, feel free to hop on stage. The link is in the Discord if you're a channel member. The first thing I want to do is, Stevens mentioned something during this about putting others before yourself. And this is very much a lost art in our society right now, and we see it in the courts all the time, where people are clearly making choices that aren't in the best interest of others, let alone the best interest of themselves. But there should be a hierarchy to things. And I'm going to give you my hierarchy, and it's based on the fact that I'm a person of faith. But the first thing I need to be is a Christian. Then after that, I need to be a husband. And then after that, I need to be a father. And then after that, I'm a businessman. So I think he mentioned something about you should be the last in the line of things. And I wholeheartedly agree with that out of Judge Stevens. He had that right. And you'll notice, too, that I listed husband above father. And the reason why I did that is that if your marriage is not right, then your children will suffer for it. And I'm raising my hand and telling you I am on my second wife right now. I am a person who was divorced many, many years ago, a marriage that did not work because it's a marriage that probably shouldn't have happened in the first place, but we did it. And I failed to hold it together. She failed to hold it together, and our children suffered for it. So I learned through my own choices that being a proper spouse has to come before being a parent. There's a hierarchy to it. And before I can do any of that, I have to be right with God. Now, you can, if you're not a person of faith, you find your own path there, but I'm telling you as one who is, that has to take precedence over everything else, because if that isn't right, then none of the other things below that work. But we see so often in our courts as we watch these hearings, and it's universal. It doesn't matter where we go. We see the same thing. We see people making choices that put themselves and their own needs and their own desires and their own selfish nature above everything and everyone. And that's exactly what's happened here with this guy, clearly. Because he's put himself in front of others all the time. And that really bothers me, because he's also supposed to be this caregiver, right? Which brings me to my second point about being a caregiver. I've spent most of my adult life caring for other people. I looked after my father, helped look after him. My wife's father, my mother, my wife right now because of her various issues. Most of my adult life looking after other people. You know what I didn't do during that time at all? I didn't go out committing felony after felony after felony. It doesn't, it's frustrating to me as somebody who has tried to do it right the whole time. And yes, I've had missteps and failed, because everybody does, but you keep trying to do it right, where clearly this guy is not trying to do it right whatsoever. And, once again, he's going to, go off to prison for it, and his mother will probably be gone by the time he gets out, which is unfortunate. But it's almost insulting to watch people behave like this, to watch people act like this, as somebody who has spent their entire life trying to do it the right way. And I hate the excuses that I see from people about how they can't do it the right way, or if they got this problem or that problem. I just don't buy it. I suppose this might lead into a little bit of what we're talking about on Sidebar tonight, because on Sidebar tonight, we're talking about leniency for people who basically commit a crime out of necessity, for lack of a better way to put it in the moment. But I don't know. He might think that his crimes are crimes of necessity, where he's short on money, so he's got to go steal somebody's credit card or something like that. But it's clearly not. He's just a bad dude. And it really bothers me. I hate it when people act a fool when they're supposed to be taking care of others around them. And the one thing I will say is that through this journey of caring for other people, we've had some very good times and we've had some very tight times. But if you keep doing what you're supposed to be doing, some way or another, things get sorted out. Things get figured out. It can be dicey and uncomfortable, but you'll figure your way through if you do the right things. I just wish more people would understand that. I stole your main point for tonight. Well, you can restate it, Lindsay. You can restate it, because we'll have a different audience tonight. The third point I wanted to make was just this whole concept of, I call it going career. This is yet another defendant that we've seen that's really just kind of gone career on us. And we see so much of this too. But so my notes say 13 total convictions across 3 states, Texas, Georgia, and California. 9 of the 13 were felonies. He's been tagged with such wonderful things as theft, assault, fleeing police, stolen credit card. All while he's got an ailing parent he's supposed to be taking care of. But I had several thoughts on this first off, I call it going career because at this point it is a career. You're spending so much time and so much energy on being a criminal. It's a full-time job between the preparation, the execution, and then the punishment. It's your life. It's a full-time gig. And it's baffling to me. It would be easier and more profitable in the long run to go flip burgers somewhere. It really would. You're not getting ahead doing this stuff. Nobody ever comes out of this successfully. It doesn't work. Sooner or later, it catches up. Wahoo, good to see you. So the more court we watch, the less I understand it. Where you see these people just over and over and over again, and they just keep going through the system. But then our system is also set up to let them do it. You know, we were talking in the pre-show regarding another matter, but we rolled around to the concept of judges and how, yes, there are activists on both sides, but so often the judges' hands are tied with the rules that they have to play under that are set by their legislatures. And because of that, we get these sentencing guidelines and whatnot that keep releasing these people out into the world. Great Granny, good to see you too. That keep releasing these people out, and then it's a rinse and repeat situation. We see them back again and back again and back again. So when we have them in custody, we're not reforming them, but then we cut them out so they do the same thing. And this guy, for all he's done, what was it supposed to be, a 20-year max, but they pled it down to 4? So he's going to go do his 4 years, and I will bet you dollars to donuts that he will be back in front of a judge somewhere shortly after he gets out. Because that's what he knows. Because the system ain't going to fix him. The system's going to punish him a little bit and keep kicking him out to go do it again. Because his parents didn't raise him right. That's for damn sure. And look, everybody falls short. I have. I'm willing to bet all of you have. We've done things that we are not proud of, whether we've been caught or not. We've done some stuff. And I can understand that. I can understand one bad choice, even 2 bad choices. I can't understand 13. I just can't. If it was his first time in front of the judge and he was saying, look, I made a mistake, and the judge gives him a probation or whatever, I can see that. Because people do make stupid choices sometimes. Again, I have. I'll admit to it. You know, I'm a fool from time to time, as I think we all are. But the repeated pattern is just maddening to me. And again, it's like going career, but the system allows career to happen. You know, how is this guy not a 3 strikes? I don't know, but I don't know what the 3 strikes law is or how it's written or if it even exists in Texas. I believe it does exist, but I think it has to be like worse stuff. But isn't this bad enough? I mean, how many lives has this guy ruined between his thefts and his assaults and his stealing of a credit card and using it and his own family? Does not make sense to me. All right, let me catch up with you in the chat here a second. Lindsay, not religious, but I do have a higher power that I make sure I'm right with. Mostly for sobriety. If I don't stay sober, I fail the other roles down the list. Exactly. There's a priority to things, isn't there, Lindsay? Certain things have to be right for you to have other things be right. And some people just don't get it. And they put themselves before others, and the next thing you know, they go career with their criminality. They need to be more Christianically sound, to use Stephen's word. Charles says, one thing to moderate this feeling you have is that you're way more likely to see the failures than the offenders who are one and done. Fleischer pointed this out in an interview once. Fair enough. Granny, our judicial system is so mucked up that the perps have no fear of doing any substantial jail time, which allows them to do, like you say, repeat over and over. Charles says Texas has a 3-strike thing, but only the most serious felonies trigger mandatory life. It's also a lot more vague than states like California or Washington. I don't know that a 3-strike should have to trigger life then, Charles. Perhaps it triggers like a 20-year or something like that. Something to really get the message across, something to get somebody off the street at least for a decent amount of time, in the fingers and toes crossed hopes that somehow they see the light. Although we know that so many just get worse in prison, but still, he ain't getting better out on the street. Again, 13 convictions, 9 of them felonies. Many of them while his mother is dying of cancer. But also, I said it earlier, and I'll stand by it, the mother's got a role in this. She failed to raise a good son. The father failed to as well, either by not being there or whatever. That tends to be more like what happens in Texas. Certain habitual offender rules trigger a 25-year minimum. Well, I'm glad they have that, but quite honestly, Charles, this probably should have triggered a 25-year minimum as well. Because he keeps thieving, he keeps assaulting, he keeps fleeing police. These things happen. But, you know, he's sentenced to 4, he'll get good time, do somewhere around 3, something like that, and he'll be right back. Maybe without his mother now, unfortunately, but he'll be back. It's just only certain felonies count towards that, and DAs tend to plead things down below that threshold. Well, yeah, we've talked at length on this channel between the regular show and the pre-show and sidebar and everything else about the concept of all of these deals being cut, and is it really the best thing for our justice system? And it's probably not. In the same respect, they're so backlogged that they have to do it, and they view it as a win. You know, it's one more tick in the win column when it comes time for the DA to be reelected. He can say he's got, he or she can say they've got a 95% conviction rate, but 99% of those 95% are just deals that are cut, but people don't look at that. But this kind of leads back to what I've talked about so many times. And you go to the hierarchy of things. For me, it's Christian husband, father, YouTuber, businessman, those things at the very end. So me at the very end. If you're not right in your heart and you're not a good spouse and then becoming a good parent, all the things below that break, which is how we keep making people who go out and do these things. We're not making good families. We're not being good enough people. We're not modeling that behavior to the next generation, and it just keeps getting worse and worse until everybody's acting a fool. The courts are backed up. It doesn't have to be this way. We make the choice for it to be this way. We make the choice to be bad people and have a bad society because we're not taking the steps to make a better one. It's just that simple. And, the more and more court that we watch here, the more and more I believe it. Call me being radicalized to it, I suppose, whatever. But it's the truth. I mean, more laws and more judges aren't going to fix what we've got. This would have been fixed if he was raised better. That would have been the start. And if he made a mistake or two along the way, even raising the best, that's going to happen. You're going to make a bad choice. But you realize it right away and you go, yeah, that was a bad choice. I know better. Mama raised me better than that. And you go, and as Stevens likes to say, and you fix it. It's fixable. This guy, what he's done is beyond fixing. It's now to the punishment stage, the retribution for it. But even that isn't great, is it? 4 years, probably out and around 3. I don't know. If you have thoughts on that, feel free to call in, chime in, let me know. But I've lectured for 20 minutes now. It's probably enough. But I do have 2 stories that I want to get into. Wahoo, I'm not trying to butter you up, Dan, but I've said similar things for years. Consequences are part of decisions. Yes, they are. Yes, they are. I try not to be preachy here at TCF, but I'm very often preachy because I'm not scared about what I think and what I believe, and I'm going to let you know. And I believe that we're just not making good enough people. And they make bad decisions, bad choices. There are consequences to it, but it's a snowball effect. And I'm not smart enough to know how to reel it in, but somebody needs to figure it out because it needs to be reeled in. Something fierce. All right. So there's two stories that I found that are out of the state of Texas in the Dallas-Fort Worth area that I found interesting that I'd like to get into because they're not things that we'd necessarily cover on the channel because we don't have a court there that streams to be able to give us this. But this one was in Fox News a day or two ago. Caught my attention. Texas couple labeled fake Chip and Joanna Gaines admits $5 million dream home renovation scam. So here we go again with financial stuff. We saw, obviously we saw financial kind of stuff with this guy in Stevens Court. Later today, a Judge Anzalone video gets posted from a live last week where she had somebody who was being sentenced for embezzlement from the PTO and Kiwanis, as I recall. But in this case, the Texas couples pleaded guilty to federal charges after prosecutors revealed they used social media to defraud homeowners of nearly $5 million under the guise of custom homes and renovations. According to the U.S. Attorney's Office for the Northern District of Texas, Christopher and Raquel Judge, that's a funny name for this, a married couple from Fort Worth, admitted to carrying out an elaborate scheme to deceive customers through their home renovation business, Judge DFW LLC. That's too many letters. Needed a cleaner name. Between August 2020 and January 2023. So they pulled this off for, 2.5 years. Pair billed themselves as a one-stop shop for custom home architecture, interior design, and construction services, luring customers through social media to advertise their business, while falsely claiming Christopher was an experienced architect. That's a hard thing to fake. I mean, I would be like, if I've got an architect in front of me, I'd be like, give me a sample of your designs. And then I give him something and be like, draw this out for me real quick on this napkin and see if it looks even halfway legit. Quote, they came out to the house, really pitched themselves like Chip and Joanna Gaines type of vibe, Lane Simmons, one of Judge's clients, told WFAA. Federal prosecutors revealed that the couple would present clients with below-market bids to secure building contracts before starting projects they never finished and ultimately left victims with incomplete residences. Pro tip, if you're getting below market bids, that's a warning, not a, hey, I found something really cool. That's a, let's stop and really do our due diligence moment. In the town of Runaway Bay, Christopher Judge reportedly was slapped with a total of 424 citations for code enforcement violations, which ultimately led the FBI taking up the case. So here's a question. Why did it take 424 citations before it finally got the attention of a law enforcement agency who could really do something about it? Wouldn't 100 be enough? Wouldn't 50 be enough? That's a lot of code violations. That's crazy. That clearly speaks to somebody who doesn't know what they're doing. So at the very least, even if you weren't going to pursue them legally through like some kind of law enforcement, I would think at the very least you ought to be able to shut them down. Nuts. There were families whose kids did not get Christmas for a year or two, Kaylee Simmons, another victim of the Judges, told Fox 4. There were families that filed bankruptcy. Plea documents indicate the Judges defrauded over 40 victims throughout 6 Texas counties involving at least 24 different construction projects. That's a lot. Court documents also showed the pair commingled victims' payments in their primary business account, often pulling installment payments from individuals to fund unrelated construction projects, amassing a total of around $4.8 million in losses. Federal prosecutors say the pair then spent the money on mortgage payments, living expenses, and even plastic surgery. Way to go. Well, they're not even old. What do they need plastic surgery for? Look, that's the picture of them right there. These are not old people. They don't need plastic surgery. Old people don't need plastic surgery. Embrace who you are. Oy. Unless you've got some kind of injury. I'm just saying. That's just my view. You might see it different. Quote, you just need to be careful about who you give money to, Roper, a former U.S. attorney at the Northern District of Texas, told Fox 4. If it's too good to be true, it's probably not true. That's what I just said. Stop stealing my line, guy. Last month, Christopher Judge pleaded guilty to conspiracy to commit wire fraud and faces up to 20 years behind bars in the federal prison. Raquel Judge also pleaded guilty to one count of conspiracy to commit wire fraud, which has a maximum sentence of 5 years. They always run to the wire fraud because it's an easy one for them to work with. I don't know. I don't know, Michael. Do you know?
Daniel.
Hi.
Oh, sorry. I was reviewing 5,000 for some eye lifts. Let's see. I'm just going over some plastic surgery. It's so stupid. How does it take over 400 citations?
That's what I want to know.
I'm going to go all Seinfeld. How does that happen? Why are you doing that? No, but why? Like, it doesn't make any sense. Like, how does it take 400? See, this is, you know what, Dan? I'm going to agree and yet disagree at the same time. Okay, so in Judge Stevens' court, we have this lady, right? This mother who I think it sounds like she went 0 for 9 with 9 strikeouts with her kids. That's not good. That's not a good batting average. Not a good day at the plate.
I'm not even sure if all 9 were hers. That was not clear.
Yeah, at first it seemed like they weren't, and then she kind of acquiesced and said they were, which I have no idea. That was more confusing. I was like, I had no idea. I needed like a roadmap. I needed I needed a manual. I needed a flow chart for that case. I don't know what was going on.
At that point, she probably needs that. I'm willing to bet there is a wall in their home with a bunch of pictures and a whole bunch of strings and tacks trying to connect everybody.
I mean, what? I'm just confused. All right, so you say, well, at some point it's really her fault because and the fact that the father probably went out for a pack of smokes in 1997 and never came back or whatever. Lot of that going on. But it's sort of the same thing with the government, with the justice system. All right. At some point, I don't even blame the criminals anymore. Look, Dan, if you go out and rob a bank and nothing happens to you, you're going to go out and rob another bank. Why wouldn't you? It's free money. You're going to do it and you're going to get away with it. Why wouldn't you? I mean, okay, maybe not you personally because you have some morality to you, but I mean, in general, if there's just a pile of something, money or goods or whatever, just sitting there, you take it, you do whatever you're going to do, and the system says to you, hey, that wasn't very nice, and that's the end of it. Well, you're going to do it again. Because why wouldn't you? A law without
I
teeth.
wouldn't do it again because I've got some financial sense. So if it was a good enough haul, I would take that money.
Well, yeah.
I would invest it properly and I would live off the dividends. But that's just me.
But the thing is like if there's no consequence to something, if it's like a guideline, hey, you probably shouldn't do this, but you do it anyway and nothing really happens to you. Okay, yeah, finally after the 90th theft, this guy is going to prison for 4 years. I don't know, still seems like a pretty good return on his investment. Still seems like it still seems like it worked out pretty good for him because he got away with a lot of stuff for a long time, and only now is facing the consequences. I don't blame him. I mean, yeah, okay, thug, and you want to label him whatever you want to label him, cool, but the system sucks. It's the system that allowed that to happen. Just like a parent that goes 0 for 9 with 9 strikeouts on their kids, dying of cancer, and none of your kids want to help. Oh, okay, 0 for 8 with, and then like the ninth at bat, you kind of grounded out. I mean, with a kid that wants to help you, but that kid's the felon. like what?
Well, we don't know the status of the other 8. They might be super felons for all we know.
They could be. well, he was the best one. All he did was theft. The others are in for ag robbery, child stuff. Yeah, I mean,
we don't know.
He only stole things, and the only reason he was stealing stuff was to pay for some of my cancer treatments, and possibly because he wanted an Xbox or 3. I mean,
we laugh, but this is a real possibility because it was never cleared up exactly why the other 8 weren't helping.
Many truths are said in jest, Dan. I mean, that's the thing. This is, I am perplexed by how this has played out. I am baffled. And again, I as much as I want to come down on him, and we in the chat we're like, this guy sucks or this guy's whatever. But no, the system that allows that to happen is the problem, and not necessarily the criminal. Criminals are born because of that. There is something to be said. Now, I'm not a death penalty person because, to me, I just don't. It's not a deterrent. I mean, it's time and time and again. It's just been proven it's not a deterrent. It doesn't stop people from doing things. And our system sucks. So you can't once you kill someone, you can't bring him back. And hate to say it, but innocent people do find themselves on the business end of the death penalty. And that sucks when that happens.
Funny you bring that up. That's the other story that we'll be going to if we have time.
Oh, well, yeah. I mean, I actually like to hear that because, we should probably delve into that. But my thinking on this is, if the justice system is this bad, why, that's why I wouldn't want a death penalty, but there does need to be teeth to the system. I'm not saying that particular tooth, maybe that's the wisdom tooth that you have removed. But the rest of it, I mean, you should have enforcement. It should be strict. But it should be even-handed. It should be fair, but it should also act as a deterrent. And if it can't act as a deterrent or means of rehabilitation, then it needs to just act as something punitive if it can't do anything else. I mean, I'm sorry, but 10 thefts or whatever, 13 convictions. I mean, at some point you got to lay down the hammer. And, you and I talk about this, and I'm not the law and order. We got to, I'm not going to stand up here and scream and yell that. I think rehabilitation should always be the first path in prison, unless it's for, stuff that we talk about that can't be rehabilitated. But at some point, 13 times, you ain't rehabilitating. Come on. And why should you? Why should you rehabilitate if the system says, you are a bad boy. Stop it. Just knock that off. Knock it, Dylan. Stop that. I'm going to turn this court around. Gross.
Well, at best, that's how he was raised.
Well, and then there's that. Look, sometimes, Dan, sometimes you do your best to raise your kids. You do everything that you possibly can. You do what you think is right. You try to instill some sense of morality and do everything that you can. And sometimes they still turn out to be assholes. I mean, it just happens.
It does.
No matter.
I'm not going to disagree with that. Because, I've got a couple of adult children who they're not out committing felonies, thank God, but I don't think they're quite as good as they should be. So, despite what I taught them, so I will agree with you on that point. But but you at least got to try. And unfortunately,
Right.
I think so many parents, they just don't even try. You know, it's two ends of the spectrum. It's like you have them because they're an accident and you don't particularly care, so you'll just collect the money you can get from the government because you've got them. Or the other side where you have them for a status symbol.
Yes.
Either
Yeah.
one of those does not work. You
No.
have to have your children because you want them. You have to have them because you want to continue with your family's legacy and build a new generation and put in the work. And yeah, there is a certain amount of you're still crossing your fingers. I'll admit that.
Yeah.
But as you
Yeah.
put it, this lady's 0 for 9 or 0 for 92 or however many she's got.
Yes. Yeah. And, you know, my dad's thing was he wanted, you know, his kids to just do a little better than he did. You know, his thing was, I am raising you so to do better than me, you know, and he encouraged that, you know, and just my mom, that was this, he's kind of similar. She was, a little tough at times, but certainly, she was fair. And, I thought my parents, again, not flawless, certainly made some mistakes, and, they got divorced when I was 14. But not once did they ever, was it a thing where it was about us? Like, it wasn't a situation where they pit one against the other, or they were, this kind of high conflict divorce. They just decided to amicably split. And it sucked. I mean, it was very difficult. It was not a good thing. Obviously for the family and for whatever, but they, I understood that. And of course, we didn't turn out to be felons. My brother and I have combined for exactly 0 misdemeanors, felonies. I don't even think, well, I don't drive, so that helps, but I don't even think my brother has a traffic ticket. I don't think he does. He might have one. I don't know. Maybe a long time ago. I would kind of hope he shouldn't, because he works for ADOT, so that would be a little weird. But, yeah. But, there's circumstances there. But again, just because you have, and look, my childhood wasn't perfect, but nobody's was, I guess. But I could never, I'm not going to sit there and go, well, that's because it wasn't perfect, I'm going to go out and commit felonies.
I know.
So
I don't understand that thought pattern. I really don't.
Yeah. But it was a weird day in Stevens Court anyway. It was 90% off discount on sentencing anyway. The other guy, the other one that we saw who was facing a second-degree felony, 2 to 20 years, got it down to a Class A misdemeanor from burglary of a habitation to criminal trespass. Those are 2 pretty different things.
They are. And think about all those people he had who didn't show. Today was the day to show up.
Oh, yeah.
They missed
It
the
was
sale.
bargain basement. Yeah, man. Black Friday, nothing. Today was Plea Tuesday. That's what it was.
Fleischer used to always say, just show up, good things will happen.
And that's so true.
Have an
And
example
that's
of
one
it
of those
today.
that's one of those things. We talk about it on Sidebar sometimes. We talk about it in the chat. It's the easiest thing you can do. The easiest things you can do. Report on your probation. Show up to court. It is not. That's all you got to do, really. And then from there, you can figure it out. So anyway, Dan, I don't want to, but you had some other story, and I'm kind of interested in what that was.
You want to hang around for that story?
Yeah.
All right, here. As long as you're here, let's go to that story. So that's
let's do
over
it.
Here. Okay. So this is courtesy of CBS News. This is also out of the Dallas area. Dallas set to exonerate man wrongfully executed for murder 70 years ago. Wednesday is expected to be one of the most significant moments in history of the Dallas County Commissioner's Court. Evidence will be presented and a resolution is expected to pass declaring that a man arrested for murder by Dallas police and later executed in the Texas death chamber was in fact innocent of the crime. What happened to Tommy Lee Walker in 1956 may seem like a long time ago, but it's never been forgotten by many in Dallas's black community. Looking into the eyes in a film from inside the Dallas courtroom, you can only imagine what is going through the mind of Walker. His unbroken stare into the camera appears to look for a reason and fairness that too often didn't exist in 1956. The said warden is hereby directed and commanded to pass and cause to be passed through the body of you, Tommy Lee Walker, a current of electricity sufficiently efficient to cause your death, the judge said in the film. Judge sentenced the 21-year-old to death in the electric chair for a murder that overwhelmingly evidence showed he didn't commit. It's not difficult to fathom what happened. They grabbed the first Negro they saw, Dallas County Commissioner John Wiley Price said. Price said that the period of the city's history was scarred by racial injustice. It was in Northwest Dallas near Love Field in 1953. Love Field is tied to too many things. When a 31-year-old woman was brutally murdered at night while walking to a bus stop. There were no witnesses, no evidence left behind, just racial hysteria and unfounded claims that it was committed by a black man. The Klan was basically rampant here, said Price. Walker lived across the town from the murder scene near a park close to Baylor Hospital. He was among countless young black men rounded up for the questioning, with some in the white community demanding justice even at the cost of arresting the wrong man. That's kind of what happened here, I guess, Price said. From all the evidence that has come to light, that's exactly what happened. You know what the real travesty was? Mr. Walker had an alibi. 9 people confirmed Walker's alibi on that night of the murder. He was with his pregnant girlfriend who gave birth to their son the next day. Still, he was arrested 4 months after the crime. Walker said after the hours of threats and promises, he was coerced into giving a false confession that he immediately tried to recant. He professed his innocence to the judge after he was convicted and sentenced to death by an all-white jury. I feel that I have been tricked out of my life, Walker said. There's a lot of other people who have been convicted for crimes they committed and were turned loose. I haven't did anything. I'm not being turned loose. Walker's funeral was attended by 5,000 people, and it's taken 70 years for Dallas to face the fact that, in all likelihood, a terrible injustice was committed. So, good on him, I suppose, for finally getting it right. Whoop, hold on. Where'd you go? All right, I'm really good at pushing buttons. There we go. So, I suppose it's good that they finally got it right, but you know, we've seen all sorts of tales like this out of the South over the years. There is a documentary floating around YouTube. It's easy to find. Just search 14 Days in May. And that is about a guy named Edward Earl Johnson. I believe it was Mississippi. He was convicted of murdering a woman. He was executed in the gas chamber. All sorts of evidence after the fact has led to his not being guilty. The warden was so taken aback by the whole situation that he ended up retiring and becoming an opponent of the death penalty before he died. So just a lot of bad stuff. You were talking earlier, Michael, about you not being a pro-death penalty person. I am not either. I used to be. But there's too much evidence out there that the government makes too many mistakes to trust them with that level of responsibility.
Well, and I think that was going to be my point, Dan, because, you know, you and I have really never talked about this too much, but it's one of those things. I don't know how you can ever really say I'm anti-government or I don't trust the government. And then at the same time, someone says, well, but I trust them to execute someone. Like the highest form of punishment. Like, you know, I know that there are people that do that a lot. And it's kind of strange that, you know, again, it's more people that tend to be in the anti-government camp that then still want to trust law enforcement and the justice system to execute people, the government to execute people. And when I was younger, When I was, 18, 20, 22, I used to be a fry 'em all kind of person. But, over time, I have seen stuff like this, like what we just talked about there. And I definitely changed on that. Maybe if the system were perfect, and I certainly, listen, I don't lose sleep if some chomo gets shanked in a prison. Okay. I don't cry about it. I don't think, that's kind of different, but I just don't want to see the government, carrying that out,
No, I don't either, because the stakes are just too high. And I mean, we see it right there. Again, I applaud the state of Texas and the people in Dallas for finally trying to right the wrong and acknowledging that it was not a guilty situation. But it's 70 years now. It's too little, too late.
Yeah,
I didn't get to this point in the story, but he has the kid that was born. That guy's in his 70s now, and he's going to attend that hearing.
Wow.
So he's like 72 or something like that now. So he's going to attend the hearing where his father, who he never knew, is finally exonerated.
And I mean, that's great. And there is a small, the tiniest grain of feel good in there, but unfortunately, it is too little, too late. I am glad that they acknowledged it. I mean, half the time, throughout history, we don't even acknowledge. And of course, this is back in the 50s. Back when we still had separate drinking fountains, and there's a racial component, and look, there still is in the justice system. We can't argue that. I mean, it's better than it was, but we still have a lot of work to do.
When we fix that, we'll break something else. There's always something, unfortunately.
Well, right, and that's always the deal, right? That's always the situation. Is we work on something, we spend all these resources to fix something, and only to ultimately break, something else. So I don't know, Dan. I don't have an answer. I don't have a solution.
Well, for this, I think it's as simple as we don't do the death penalty anymore. That's where that's at, because again, I don't think it can be trusted. Not for something you can't take back. I mean, it's bad enough you put somebody away for 30 years and then find that they're innocent and they've lost 30 years of their life, but at least they've got something left. At least they've been able to see their family and stuff like that while they've been gone. But all righty, Michael. Well, thank you. We'll see you tonight for Sidebar, yeah?
Yes, thank you, Dan.
All
yes,
right.
Sidebar tonight, 8 p.m. East, 5 p.m. Pacific. Sidebar.
Yay. Michael, ladies and gentlemen. All right, so speaking of Michael, he and I will be starting a new show soon, In the Blind. There's probably a link posted somewhere in the chat for that, if you haven't already subscribed to that channel, but we're looking forward to that. If all goes well, we'll film the pilot tomorrow, probably posted on Thursday, and February 2nd, that Monday, will be our first show. It'll be fun. Michael and I will not know the topics we'll be covering ahead of time. That is why it is named In the Blind. We've got no idea what we're going to talk about until we are live. So no safety net, no takies, backsies, nothing. It'll be cool. So join us for that. All right, my friends, I'm going to go ahead and call it a day here. We will be back for Sidebar tonight. Actually, the next thing I'm going to go do is get that post done. So we'll be ready to go for tonight, and that's at 8 p.m. Eastern, 5 p.m. Pacific. We'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour early for channel members. But thanks for hanging out with me today. I hope you all had fun. I know I did, and hope to see you all tonight. Take care. God bless.